Clyde. Come here. Clyde. Come here. Come here, Bubba. Come on. Hey. Clyde. Come here. All right, well. Hello, chat. Good evening. Yes, Jane and John Doe, been a member for 2 months. Thank you for your support. We want Clyde. Well, Clyde came trotting in and looked at me and was like, "Not today, fat man. Not today, fat man." And he trotted off. So Clyde said to suffer. Oh. So thank you guys for taking care of something there. My apologies for running a couple minutes late. Gotta address the things as they happen. CLSU BWA what? Subway. Okay, well, there's Subway, but then there's the CL. That didn't work out really good there, so. Oh. I know. Well, they were trying to do some Clydes, too, so. Clyde is his own dog, yes. Moose Nut says, "You're glad I'm okay." Well, thank you. I'm, yeah. Mexican Vader says, "Fuck you, fat man." Says Clyde probably. At some point, he probably says that a lot. Clyde does it enough. Just in his actions. Okay. Oh. Yeah. Hold on. Yes. Let's see here. So, all right, guys. Day 22 of Kieran Reed. We are on to Judson Welcher. Remember, he's the guy at Aperture, and he went through and we saw with the paint testing and all that stuff, and I'm just like, I wasn't impressed by any of that. But today is they're still on direct, but I also know this is today for Alessi. I don't know what happened. I mean, based off reading Twitter, it's as the Jonathan Haidt thing of one screen, two viewers, two distinct movies. It's a very real thing. It's a very real thing, and I saw this at somebody's. This is correct here, I think, and this is what I'm going to show you guys because I don't know for sure what happens here, but here we go. I might need some of Clyde's THC meds. Okay. Well, here you go. So this is a lady named Sue O'Connell. And saying several jurors are writing vigorously as Alessi's going through calculations. Many jurors write in their notebooks when Alessi cites the age of a report. I don't know what that means. Some jurors are definitely following this. All the jurors have been awake and alert since I entered the courtroom. Okay. And the next one over, John DePetro, was like, "If people want to pretend this cross is effective, be my guest. The jury looks bored." This is, once again, we're to that point where everything's a home run or everything is a swing and a miss. So I don't know. I don't know here, but I will point out that this is like make or break for Kieran Reed. This is going to be make or break. I mean, I don't think they have to hit a home run, but they thoroughly have to fucking tear this apart. Because if they don't tear this apart, it's going to be damn near impossible for Arca to do their thing. So, we'll see. We'll see. Suki the Hangry. Well, if you got the Golden Corral gift certificates, you shouldn't be hangry. And now remember, thank you, Suki, for your support. All right, guys. All right. So, let us get started. Let us get started. Also, today's National Hamburger Day, chat. Please keep that in mind. Please keep that in mind. We've got Carrion Red Day 22. Okay. Oh, we have closed captioning too. Very nice. Very nice. Nice. It's kind of what we need here, chat. So let's go. Let's go. Remember, they started at 10 o'clock today, so we're an hour in, chat. This is how awesome we are.
Yay. All persons having any business before the Honorable Beverly Cannoli, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, we shall.
Yeah. This guy is still not selling it. They need that redheaded guy from before.
Be heard. Let's see the call.
Oh, share the screen? Okay, sorry, chat. They need this Hear Ye guy to be the guy from the first trial with the red hair. So, if I have any blood pressure meds, take them now. I do not have any. So, they would have the redheaded guy from last trial would have been perfect.
Commonwealth of Massachusetts. Court is now open. You may be seated.
All right. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors. I have to ask you those same three questions.
All right, guys, so we're getting back to it. Here we go.
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you two other questions. The first is I'd ask you to turn to your PowerPoint, slide 110.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? Could you go back one, please?
Okay, what are we?
Perhaps it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Thank you, Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you,
So we need to take this.
Sorry.
could you take the PowerPoint down, please?
That was in a different spot on this line. Hold on a second.
That's right.
Thank you. Sorry, I had asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if you're reading from something or not reading.
Looks like he's counting on something. Are you reading from something?
no, I am counting on my finger.
Okay, thank you.
So
I was about to
I am
say, it looks
counting
like he was.
the Ring video doorbell, Mr. O'Keefe's.
Although his computer's on, something's on. That should be turned off. Till you're told to look at shit, you shouldn't be looking at shit.
Height, the type of shoes he's wearing, because I need the same type of shoes. My exemplar inspection, where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on
If you collide at more than 8 miles an hour, you'll break the polycarbonate lens. I don't think that's true at all. I bet I could throw like you could toss a baseball at 8 miles an hour, and I bet it doesn't break it. I just don't. It's not an issue of speed. It's the issue of force. I don't.
the data and based on the physical
doesn't make any
damage
sense to
in
me.
your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with a collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions.
Okay.
You've written some papers on side swipe collisions or clipping. Can you describe for the jury and explain what a side swipe collision is or a clipping and how that may or may not differ from?
Okay, I don't know what they are right now, but a side swipe collision, those sound like, and a clipping sound like two different things to me. Clipping is like he's standing right here and it glances off him. A side swipe would be like that. That's a side swipe. I don't see how he could claim that's a side swipe. That doesn't, at least to me, that's how I look at him. So
A direct hit on a pedestrian impact.
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's the glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is
it's just like if Mike Tyson punches you in it, he catches you right here. He, hits you on the ear with his glove versus hits you right in the fucking face. Yes, that's not there's no earth-shattering information being revealed here.
referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact has occurred in the center of the vehicle.
But you just told us it was 23 miles an hour. So you're like, I don't know how to calculate the data, but here's what the data I have. What the fuck? What the fuck are we doing here then? What the fuck are we doing here? Like, what are we doing? What are we doing here, brother? I'm just saying, like, I'm just telling you when it sounds fucking weird to me. I'm just telling you when it sounds weird to me. And I'm just a humble retard.
And we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they've landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
Maybe.
In your studies
If you're sloppy drunk, you're not doing that. And John O'Keefe was kind of tanked.
of direct pedestrian collisions by front or back bumper as opposed to side swipe or clipping with somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Accident Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
All right, chat. Real quick, we do need to pause real quick, so we got some things to touch off here. Shredder S07 with 5 subs. Thank you, Shredder. Barton Bella with 5 subs. And Kat, not Kat Williams, with 5 subs. And guys, Kat, check her out over on here on YouTube. Does great content all the time. Very good follow. Definitely take a look. But Kat with 5 subs as well. Just coming out here, guys. Just doing their part.
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part too.
They're doing their part, chat. Are you? Something to think about out there. So. T-Rex trucking more for $9.99 real quick. Chickasacky came in. I did some research and it would take between 20,000 and 100,000 newtons of force, which is a lot of force, chat, to do what he's saying happen. Some of you are out there like, I know what the newtons are. Yes, you're right. And if that's all the force is specifically concentrated on the taillight lens, yes, that was done. Yeah. So, it's good stuff here, chat. Good stuff. My cat's name is Karen. Well, did your cat cause the accident? But thank you for 5 subs as well. Thank you. Thank you, Karen the kitty cat. Or should I go meow, 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 meow? Thank you. Thank you guys for the support and your generosity. So let's keep going here. Yes, that's what I know the N standing for is newtons. Okay. Well, let's keep going, chat.
Oh, sorry.
Buddy needs some
I fixed those other 2 slides.
he needs some cheaters.
Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Oh, let me see if I can.
Okay. All right.
So AOI in this
Why?
diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please.
Now, did he show that to show John could have gone like 30 feet? Because that kind of bleeds into like what Trooper Paul was claiming last year with the spinning pirouette jump flip. And then this is a okay, so this guy had a trauma case. But this guy was a fender vault, so it's not even the right part of the car. This is a fender vault. This isn't a quarter panel strike. And also, look at all the things this guy suffered. Subdural hematomas, subarachnoid hemorrhaging, intraventricular hemorrhages, fractures of the right posterior ribs, bilateral hemothorax and pneumothorax, meaning he pierced his chest cavity with his ribs. Liver lacerations, right upper extremity wounds with a vascular injury, multiple abrasions. Okay, like, I mean, this is all road rash when the guy probably, like, flew down the street. But, look, none of this happened to John O'Keefe. So, you know, and the potential for a lower extremity trauma, well, I mean, all this stuff right here would have been, you know, torso and upper body and head. Also, the one thing I don't think Judson Welcher talked about lately, and this is just modern vehicle construction. If you look at a car from like the 50s, it's got a big flat front grille and all that. When you got hit, you would get like sucked under the car because it'd knock you over. Cars have slopes on the front. There's safety engineering put into them. So there's differences. Like I said, that Lexus is engineered to get you, if it hits you, to shove you away. If it can. But it's going to strike you. So I don't know if he's going to get into that, but that's something else you should probably notice here. So.
What does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is,
yeah, there's no broken bones in the arm because the guy sustained all his injuries to his torso. That part of the car right there hit him right here. Multiple fractures, bilateral hemo and pneumothorax, which means he was like in really bad shape. It also looks like his head got struck. His head got struck in a really nasty way with the different hematomas. Like, he got hurt really fucking bad. This is not what happened to John, so I don't know why this is applicable.
he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes,
Do
ma'am.
you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury. So no fractures.
Yeah, but that's not what happened to
If you
John.
look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Okay.
You can take that down, please.
That's still not what happened to John. I don't know why. Where are we going with this?
Dr. Welch, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe?
I don't think
Or
he can
equipment,
actually
Mr.
say
O'Keefe.
this.
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your Honor,
pleasure.
I would move into evidence subject to redactions. Dr. Welcher's
But none
PowerPoint
of that
presentation.
happened, though. None of the other injuries happened.
Yeah, Your Honor, thank you.
No upper body injuries happened, though, dude. So that was a very short little bit of direct there, but none of the other injuries happened to John. That's the problem here with this argument that he's making. But none of that happened here. John suffered none of those injuries, did he? No. All the injuries he suffered, based on the neurologist, is from the brain spicking around with the counter coup. None of that was external trauma like that. It's all from hitting the ground and then the brain bouncing around. Like, I don't know. This is just stupid. Unless there's more to it. I don't know, guys. I don't know. I guess we'll see.
In both the flash drive and the notebook.
On the representation, it's consistent with the same set. I don't know.
So let's put them both together now and decide later. Okay.
Those 2 slides are incorrect on the flash.
Okay. So we'll switch that.
That was-
Thank you. What exhibit number is it?
This guy's had to change his presentation so much. Like, I will say that's going to be a pain in the ass to keep track of. So that's going to be a pain in the ass to reconsolidate and figure out
All right,
what the
Mr.
fuck you're
Leslie,
looking
whenever
at.
you are ready.
Thank you, Your Honor. If I could have a moment to set up.
Sure.
All right, Alessi. Chad, I'm not joking when I say this is probably going to be it for Karen Reed here. This is probably it, guys. This is Karen This is Karen Reed's major push. This has to happen. Brian says, when did this originally take place? January 29th of 2022. So, Kimmy would say, remember the guy who plowed into people? They all had different injuries. Yes, none of them had no injuries, though, like John O'Keefe. So, nice try. Nice try again. Is this a watershed moment? I don't know, but this is going to be big because unless he doesn't fucking crush this, it's going to be really hard for ARCA. We'll see, though. Let's see what happens.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you.
Wow, okay. That was a little interesting. That was his way of kind of That makes him very pleasant and personable. That's almost I would argue that's a bit of there might be some people out there who don't believe this, but there is psychological warfare involved here. That was his way of kind of controlling the conversation. That was kind of interesting. Very interesting by the sneaky doctor. Yeah, that was a very dominant move. Trying to. Yeah, that was a shit test. He was checking him. Unless he got cut off guard there.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in and giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics.
Mm-hmm.
And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly, yeah.
Okay, yeah, certainly for the court of law,
It ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it
Is this guy gonna fucking Reddit everything? Jesus.
relates to or it's used in or it's suitable for a court of law, the analysis. You'd agree with that as a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying.
Yes, I'm trying to present truth in court. Just say yes. The idea is I'm trying to give people an accurate look on things. Oh my God. Oh my God. Just say yes. It's almost like if you ask them, is your name Judson Welcher? Well, it depends on who you ask. My kids call me Dad. My wife calls me Daddy. You know, and the guys at the truck stop call me Cum Dump. Like, what are you doing? Really? Like, stop. Yes. Zaddy. Yes. Yes. Oh my God.
Sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's...
That means they're either true or not true, or partially true. I mean, that sounds like a guy who's worried he already made fucking statements that are going to get his asshole eaten out on, but we'll see. We'll see here. The guys at the truck stop call me not so rough. Yeah. Oh, all right. Let's see what happens here. Okay.
Let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now you simply follow the data. Is that correct?
I try to do that.
Okay.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So in terms of you've agreed.
Okay, guys, here's the problem. When you ask questions and you're trying to fuck with somebody, if you have to be careful, because if that witness can give a reasonable answer, the jury's going to accept the reasonable answer. This guy's like, look, I'm not perfect. I do my best. You know, everybody in the jury says, fair enough. I'm not, nobody, remember this, guys, Ted Williams, the best hitter in the history of baseball, at his peak hit 450. That means 45% of the time he got the bat on the ball in a positive way, offensively. That means 65% of the time he didn't. You know, doing your best in this situation. Guys like, yeah, I do as good as I can. Everybody on jury's gonna be like, yeah, good, fair enough. You gotta be prepared. Like you gotta be careful asking those questions because, you know, of course he's gonna say that answer, and everybody on jury's gonna be like, yeah, makes sense. That's not a gotcha. It's not a gotcha.
Agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation,
Is he reading?
analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath.
Okay, is Alessi trying to get to here? Is he trying to get to the idea that you kind of just made shit up as you went and then later on you're getting peer review? Or is he saying you should only use peer-reviewed accepted principles and peer-reviewed methodologies before, like, that's the testing should be built on stuff you know has been peer-reviewed? I think that's what he's trying to do. I think that's what Alessi's trying to ask. But I think, like, this is left an open hole here because he's making it sound like, yeah, this wasn't a good one. This wasn't a good one here, guys. Yeah, if he's trying to say no one's ever done it, fair enough. But he could have asked that question differently and saying, you know, you should be sticking with peer-reviewed methodology. And those methodologies should then be part of your testing. You shouldn't be making shit up as you go. Not in this case, because you can't send it out. I think that's what he's trying to get at, but that was very clumsy. Let me see here. Garrett says you can submit the methodology. Not every time. That's not always going to be possible. So let's see here.
And looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, should
to
I
get
interrupt
peer,
you?
I need to,
Go ahead and answer your question.
you're asked peer review, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir,
Okay, so yeah, unless he's trying or he's underpinning methodology principles, not case fact review. Yes, but if Alessi's this imprecise the whole way, this is not good. This is the guy. You have to be as precise as a fucking laser guided bomb. And Alessi's kind of just being willy-nilly. Like, you got to be very precise. Geez, I'm not impressed right now. I'm not impressed. Come on, Alessi's got to get his shit together. So,
my question is not your analysis here in this case.
Oh.
My question regards the methodology that you use here. Is the methodology, you said 26 references, right? My question is simple. Is the methodology that you use for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly,
Okay.
exactly. To do it apply the scientific method
Okay.
without bias being part
All
of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias
okay.
is part of.
Yeah, he's trying to do teasers, but this guy's thoroughly defending. This is not a good look by Alessi right now. I'm not impressed by this. This guy is like swinging back.
The larger term, are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you
Sure.
like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively.
I mean, he's trying to say, like, do you agree you can buy your own bullshit? And this guy is doing a great job at dancing around it. That is, I can tell where Alessi wants to go, but he's not going to let you. And Alessi better change course quick, because this is apparently, the die is being cast right now, Bob. And you'd better figure out a new game plan, because I think this guy is not going to let you do what you want. He's not that stupid. He's not fucking Shannon Burgess.
Gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree?
Yeah, that I was about to say that sounds like it could be like stress fracture analysis, but then you analyze why it failed. Okay.
Read that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second.
Okay,
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But
So here's my question. If I'm Karen Reed's team, I'm finding out every time this guy's ever testified. I'm finding out how big of a faggot he is on the stand. And this guy is Redditing. This guy's being a Redditor. And they didn't, like, you would prepare for this. You would do mock trial, mock cross-examination. You'd find somebody who's an engineer. You'd pay some engineer to come in and have him go, actually, the whole time. That's what you would do. I don't understand why they're not prepared. I don't understand why they're not prepared here. This is this is something I think they should have really spent time on. Yeah, this is not this is not looking good for me, guys. It's not looking good. Bart Bellis is a member for 17 months, says he fixed the other two slides. Why did he say that? Is that okay? Well, they had to take stuff out yesterday, so I'm assuming that's what they're referring to. The judge said take it out. I don't know, though. Bella says for 17 months. Bella, thank you for the support. I appreciate it. The Sky is a neighborhood for £4.99. You know, £5 sterling. The Kings sterling. Says, how is he not allowed to bring his homework in from another case? It's like making your own homework. Yeah, but he's using it as a demonstrative. He's an expert. He's relying on that stuff. Now, what would happen is, ideally, that is part of part of his report and stuff. You know, Alan Jackson and them could go back through that case to make sure that actually got admitted properly and that he was accepted as an expert. But it's a demonstrative to help the jury understand things. Erica Thorpe for 7 months says, Safa, happy to be here. LOL. Well, thank you, Eric. I appreciate it. And then Malcolm X for $14.99 in Australian dollary doodles says, the truth exists independently of all subjective experience. Correct. There can be truths about subjective experience, but that's not the same as the truth itself. I'll die on this hill. Yes, and I think any true scientist would agree with that. So this guy is already kind of worming his way around. And then Jefferson Post, been a member for 9 months. Thank you for the support, man. Says scientific method is to try to prove yourself wrong. Yes. You seek out trying to disprove your hypothesis. And if you can, then obviously you redo the scientific method. So yeah, this guy's a little, I'm not impressed. But unless he's not helping things here, chat. I think they're called koala dollars. Yeah. So here we go.
But when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end? How do you then not get your hypotheses up front when under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses at the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question to make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mm-hmm.
You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
And
This nerd talk might not sway a jury, but this might come across as Alessi looking like a dumbass. So this, you got to be very careful because the jury not being swayed by the science, but they see this guy, you know, avoiding Alessi's questions like, wow, this defense attorney's eating shit. So it's a very critical thing you have to be careful about here. You know, they might not understand what's going on, but they can see what's going on and they can hear what's going on. And they can interpret that maybe not how you want. Be very careful.
once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence.
1, 2.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses, the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clearer is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in
Yeah, him writing things down though, like him taking notes, that's a little weird, but think about it this way. He's making sure he understands you. That does show not necessarily a guy's deceptive. That shows a guy who's very deliberate. Now, I get it. He's being all wishy-washy here, but I think in general, like, remember, he's an expert witness, so he's trained to be a snake. But he's also trying to be very deliberate in what you tell him. So he's writing it down. Okay, Coffany, stop defending him. I'm just telling you how this works, guys. This is discussion here. This is a discussion of what's going on right now, because right now, guys, Alessi is not making progress on this. And Spud Gun, you said it, man. Alessi's on the road to felting right now. Alessi's on the road to getting felted. So this guy is not cooperating, and Alessi needs to figure out a new game plan.
accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know
Ooh.
him.
okay, familiar with
He does
Trooper
know.
Paul through his
Interesting.
reports in this case, correct?
Correct.
Yes, I get it. He can recover.
And are
I'm
you
not
aware that
impressed
he
with
was assigned by lead investigator, former trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he
Yeah.
issued a reconstruction.
That's a lot of shit in one question. Surprised there was. Hank is not objecting because he knows this guy's going to be able to dig his way through it. So Hank is here's an indicator of what's going on. Hank is confident this witness can hold his own, so Hank's not getting involved.
Report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained. And so do you recall, is it the date, January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th
Okay.
of 2024, your firm Aperture was
He's fucking using his laptop again. Look at him. He's reading and scrolling. Why isn't Alessi stopping him? He's not supposed to. You can only use your work when it's time and you need recollection. He's not allowed to do this. And it keeps going. I keep looking over and catching him doing that while I'm listening. Unless he needs to say something, you're not allowed to do this. And this guy is supposed to be a seasoned expert. This is not professional at all. Why isn't Bev stopping him? I don't know. She's an idiot.
Paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Well, see, this is what I don't understand. This is what Hank Brennan didn't ask either. What's your hourly rate? Just ask that. What's your hourly rate? Because you know what your hourly rate is. If you say no, I find that hard to believe. So he's not a founding partner. He founded a different company.
Call whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're an engineering company. We bill for our time.
So you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
That's a good point.
Know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Okay, well, you were about 9 months in, so you know if they weren't paying. Because these guys took over in like 2024, so it's been about almost a year. But this is I don't like, that's not a shock that he doesn't know billing, guys. That's not a shock he doesn't know billing. Just like Rentschler and Wolf don't know the billing. Like, that's not everybody's job. Like, that's not an issue for me. So
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that time now, correct? According to your own answer you just gave.
He's fucking reading, but 2.5 years? What the fuck is 2.5 years?
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what? Less than a year ago.
Understood. I'm moving on to the.
Oh, fucking A, Alessi. Oh. He misspoke. That's a big fucking misspeak, though. That makes you sound like a fucking idiot. That's not good. Like, misspeak is like red hat, blue hat. Not you've been working on this case for 30 months versus 9 months. Like, you have to be precise. God, if he's going to fucking he's got to get on his horse and go here, chat. This is not impressive. Alessi is not doing this. Joe Loy says, but he came with the precise date. Yes, after he stepped all over his wiener. And then this guy corrects him. And whether or not this was right for him to correct him or not, this guy looks like a hero right now. This guy looks like the hero, and Alessi looks like the zero. That wasn't good. That's not a good look.
Next question, because I want to move away from that discussion and just go right to the bill. You, as you sit here today.
And now you move on like this after you get chided. It's not like you're shifting. You're not intentionally shifting. You're running away. Like he just landed a punch, and now Alessi's changing tactic. Aaron says, here's a stretch. But he looks credible now because Alessi keeps stepping on his dick. You can't do that. Alessi is not on his game today. And this is when it matters most. This is about when it could matter the most. Like I said, guys, this will make or break Karen. This will make or break Karen because this makes or breaks Arca. So, yeah, this is it.
They do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And was it that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The obligation is the difference.
Exactly.
Why did we ask that one? Why? Why did we do that, Alessi? That was not like, what was the necessariness of that? Like, what was the necessity? So, Steffi says, I want to buy it. So, the jurors are the taxpayers. I get that, KLF, but that doesn't really get into bias or anything. Like, I don't know where Alessi's going. Alessi's been swinging and missing so far, so I'm questioning him, as I have every right to do.
So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
Would you agree they've at least paid part of, if not that whole thing? Yes. But yeah, guys, these guys aren't cheap. These dudes are fleecing the Commonwealth for a lot of money. Expensive hoes. Remember, these are whores. They'll say whatever you want if you pay them money. The whores aren't cheap. Good whores aren't cheap. Luke says, just admit the contracts he signed. Yeah, but he can say, yeah, I think so. I don't remember. And you know what everybody's going to say on the other back end of this? The jury's going to sit there and say, yeah, that makes sense. Okay.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates, you said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess.
Like 6 months is actually like December. You're about 9 months now, September. This is just, what are you doing? What are you doing, Alessi? You're trying to like actually on the dumbest shit ever. God. Alessi, this is not, you are not scoring. You are not. What are you doing here, man? And yes, he keeps reading the goddamn computer.
It's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your
Okay.
office, correct?
That I don't know.
Yes, and yes, they're. What's that? Yeah, I mean, he understands how much a contract is, but he doesn't know billing. Like, yeah, but here's the thing. Like, these guys are not cheap. They're engineers. They're time. Like, they're gonna charge you a lot of money. His billable hours are probably more than mine per hour. I bet he charges more than $300 an hour, chat. And then remember, it's not just him. It's going to be a team of people. And this is not the only case he's working on. He's probably working on multiple cases at a time. So, yeah. He's probably salaried. Well, as an executive vice president, I bet he gets revenue sharing because he's probably a partner, technically. I bet he gets revenue sharing.
No, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you?
Yes.
Yes. Sir, I'm asking.
Yeah, could you direct me so we're not wasting time?
Well, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
There you go.
I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refreshing.
All
What
right.
would you like me to start with?
So-
Refreshing?
Go ahead and start with, go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? Do you
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I'm now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right. And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you.
Mhm.
Now, switching topics.
When he does that, you misquoted me. That makes him sound like Alexi's dishonest. He is using verbal tools here to combat and fight Alessi.
You submitted an updated PowerPoint presentation, the one that we that you went over on your direct examination.
Here's the thing. Maybe you guys are right. Right now, if I'm scoring the fight, these are, 10-9 rounds for Welcher. So I'm not impressed with Leslie right now. Just telling you. Spuggin says yes, Alessi's getting felted. Yeah, it seems like he is. Also, David from Making Law Simple, guys, check out David on Making Law Simple for $5. Thank you, David. We're going to have to do a Lego stream soon. So I got my Lego train for 2.0. Because I had some leftover money after paying Arca. Well, thank you, David. Thank you for helping pay Arca. Karen appreciates it. And then no mail for 4 months. He says, Alessi is getting felted today. He is unprepared. Like I said, I just don't think they mock trialed this guy hard enough. We'll see, though. Because they could have called around and said, hey, how does this Welcher guy testify? And they'd be like, oh, he's an asshole.
You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on one second. Dr. Welch, I'd ask that you not do.
Not looking.
anything.
Okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor, please
Yes.
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see Counsel Ataiba while you pull that up.
Okay. What the? I'm not seeing Alessi. All right, chat, let's go ahead here.
Mr. Alessi, I need you.
All right.
I need you over there. So,
Your Honor, yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me a question?
Finally,
Yes. When did you?
finally, Bev is like, he keeps stop using the goddamn computer. This has to stop. This has to goddamn stop, and I'm finally glad she did it. Oh.
You create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Right, so
This is
you created on January 30th, 2025, you made your,
13th.
pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right, if I could finish my
Well-
question, I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in the courtroom, so but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days.
about statements. Like, okay, that like he's answering the question. Alessi, why'd you ask this question? Because now what he's going to say? I took out what the court told me to remove. I got told to remove things that were not admissible. What's a jury going to say? That makes sense. Once again, he's allowing him to make honest, like he's allowed to give reasonable questions. Oh, this is not good yet, guys. He's slimy. Yeah, but Alessi's letting him get away with it. Alessi's allowing him to do this. So Alessi's doing a shit job right now.
I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
Right. So
That was the second half.
I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this. And
Please.
if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right. So that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why?
I know where he's going with this. You know what his answer is going to be? I had to because I was told to because of what happened in court. The judge told me to fix it, or I had to fix it because of something you complained about. Alessi's just walking into fucking rakes right now that Alessi threw down.
And you just leave it off and then discuss.
That's what's going to happen here. I guarantee you that's his answer. And this guy looks perfectly reasonable, like he's getting attacked for no reason. That's the problem here. This looks fucking bad.
It in terms of testimony.
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So
Okay.
the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as
Ooh, so he did remove something. Okay. Interesting. He removed something, and there's no clear answer why he removed it. Wow. People in court says you can't think this guy looks reasonable. If you come across as berating this guy and writing his ass and he's giving reasonable answers, yes. Right now, he's still kind of giving an answer. Is the jury going to buy it or not? And I think the jury will believe him here. So, yeah, unless he's allowing him to do this.
accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until
How would
April.
he know that?
So
I don't
a
think
clip
that helps,
that
man.
has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh,
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me
and-
close it.
Wow. Bev is mad. He keeps fucking around with the computer. Whoa. Yeah, Ag, this is the worst expert. No, Shannon Burgess was worse. You know, in the Johnny Depp trial, the guy who was like the guy was even worse. But this here is very unprofessional. He should know better than to fuck around with his computer.
Sorry, I was trying to answer his question.
So I'm going to ask you to close the.
Yeah, that's probably a good idea.
Just let, thank you.
Thank you, Your Honor. So assume the clip
Now he's like he lost his blankie.
that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brandon.
It was someone associated with prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route that they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that should be looked at. What's the basis of your understanding that he found new information?
I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made? That
Wow,
Mr.
Bev allowed that
Burgess
question.
found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir,
Shouldn't you care if the data is correct or not? I mean, that might be a better question saying, is the data correct or not?
has Aperture ever submitted a report, a changed report in the middle of a trial for your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself, sir. Can you then, for yourself, recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess again?
All data is correct. It's data, not
Great.
well.
Love to do the rest.
Data might not be correct. You don't know if it's correct or not. Just saying I rely on data. Well, how do you know the data is correct? You don't know if the data is correct. Like, how was it measured? How was it obtained? Like, I hate this argument of, oh, it's data, data, data. You don't know if the data is good. You don't know if any of the data is good. All right. Oh, God. Alessi is not getting it done, chat. Alessi is not getting it done. Whiskey 77 for $20. Thank you, Whiskey 77. Check him in 3 Beers Out on Assholes React, guys. Find him here on YouTube. A-Holes React every Sunday night at 9 Eastern. But all names of gray are DEI hires. That's a lot of DEI hires. I don't know what they got hired for. T-Rex Trucking Mort says, I'd hate this guy if he started talking like this to me at dinner, I'd leave. I don't have time for pompous, arrogant people like him in my life. Yeah, you'd like to think he probably doesn't talk like this in front of family and friends, hopefully. Knock on wood. Jefferson Post says, the lawyer looks dumb, the witness looks smarter. Yes, that's a concern. It does get to be a concern. Same diff says it does get to bias. Aperture bought a car to change the difference, to charge the difference. It's a scheme. I mean, well, what are they supposed to do? They have to get a car to test. So, no, I mean, like I said, everything they've done so far, the jury's going to sit there and shake their head and go, that's reasonable. That makes sense. That makes sense. That's all they have to do. It just has to make sense. Jefferson Post says, fleecing Massachusetts. That feels great for me. I'm sure you're looking at it as, well, if it's not me, it's someone else getting one over on him. Spud Guide for £5 sterling. The Kings sterling. He says, Sean, make it stop. This is no BN. Yes, it's very no bueno. Alessi's fooked. I don't know. He's just, this is not good. This is not what Karen needs. Tech South says Aperture got paid with the big golf tournament checks like Happy Gilmore. Soul Souffle says, can Alessi bring up the prior cases where his testimony was excluded? It's going to be in a very limited scope where you could do that. Maybe, maybe not. I don't know why it got excluded. But if it's a 1984 case, probably not. But it's possible, but it's going to be very limited. Remember, if it's just one case, you would need like a series of them. So, Brandon for $5 says, Alessi takes the L in front of the jury for today, but comes away a winner by the end of the day. Okay, maybe. We'll see. And will redeem himself tomorrow. Maybe, man. But generally with this stuff, you only get one day. You can't count on winning tomorrow. It's not guaranteed. But thank you for the super chat, Brandon. Johan Naxos says Alessi is using his autism against him. I get it. Yeah, but the jury may not. The jury may not. That's the problem. If these guys are going to talk past each other or talking, nerdese, then the jury's it's got no effect. T-Rex Truckee says he keep using that device almost makes it seem like he's looking up facts on a calculator or whatever it is. It's a laptop. He's looking shit up on his laptop because he's got all his files and data there. It's his hug box. It's what he goes back to. He's got everything pulled up. And he's not allowed to do that. You're not allowed to do it as an expert. If your recollection can't be you have to say, I did a report. Can I look at it? Case's team has been very good at collecting themselves overnight and coming back with the next day of bombs. Yeah, but you can't keep doing that. Some days you got to come out swinging. Aaron says, if I were a jury, I'd see this guy as a dick trying to lock someone up with life for playing dress up. Maybe. But you also, some of these jurors might be retarded and say, oh, wow, this guy looks credible. This is the danger right now. Karen's in a very dangerous spot. But yes, it's interesting how Bev did that timing. So we'll see. We'll see, chat. So let's take a check here, see where they're at.
Prosecute.
Okay, we come back. Oh, look, Paul's not over on the end anymore. Paul's sitting next to bald man. Paul no longer near all bald men. Paul stand out. Paul wonder what for lunch today. Paul hope it's cheeseburgers. It is cheeseburger day. It actually is National Hamburger Day. But Paul wonder. Paul ponders. All right, Chad, here we go.
I'm sorry?
During the lunch break, I know it takes you a while to set up in the morning. I'm going to actually take all that down during the lunch break, okay?
Oh, wow. Bev is like, I fucking had it. Take your shit down.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made.
Bev told him to
your
take down his
PowerPoint
fucking shine box.
And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday,
I wouldn't expect
correct,
them
sir?
to.
Day after Memorial Day.
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
What?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up, and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going on. I mean, there's been scheduling.
I'm sure you got a lot of emails about fucking Burgess and, all kinds of bullshit things there. I'm sure you got all kinds of comments about people. He's like, and then all these people told me they were going and telling me I should neck myself, and I should neck myself for hiring Burgess, and we should do all that. Yeah, it's called, and these people were telling me about pro gamer moves, and then they started saying the N-word over and over again. Yes, called we do a little trolling. Yes. Did they send you any porn? Any gay porn? Any child porn? Yes, I get a lot of boner pill emails. Yes, I'm sure the IT guy is losing his mind knowing this guy's opening up random emails. That's gotta be enthralling to the IT department. Soul Souffle for $9.99. Thank you for the super chat. Says an excluded testimony case filed May 2022 for using himself as the test dummy, using statistics unrelated to the case. Same shenanigans here. Okay, I mean it depends. I don't know. I'm sure they know about it, but who knows? Who knows? I don't think they know, but we'll find out. I mean, like it is what it is right now, guys. That's going to come down to what they can show.
You know, when am I going to come? Things like that.
Are you going to?
How then was it?
He had to ask Hank, when can I come, Hank? That's the emails between them. Hank, can I come? Hank's like, yes, you may come. Oh no, that's so sad. Hank's his dominatrix.
Determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were prosecution, there should be communications while this trial is going on relative to you amending your PowerPoint that ended up
Okay.
in amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Going to switch topics.
Okay.
One of the goals of
Supposed to
Aperture's
play, thank
analysis
you.
and reconstruction was to determine the location and timing of certain tech stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is event data recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, event data recorder.
Sounds good.
EDR data does not show the location associated with a tech stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a tech stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question
What?
slightly different way. The EDR data
Okay, hold on.
does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a tech stream event, correct?
That is correct.
Instead, every tech stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple tech stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and tech stream.
I'm not, sir, I'm just
Are you
asking a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes has information about GPS.
God, if this doesn't help where this guy's trying to make it look. I don't think he's trying to actually here. I think he's like, unless he sounds like a tard. Yeah, I think the point they're trying to get here is that the Fairview trip is 11:59, 11:62. Okay, but I don't think he's not getting to this in an effective way. Unless he's kind of fucking this up.
Yes, date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to tech stream.
So let me ask it a different way.
Okay.
The tech stream data
Shipping
indicates
on
the number
coke
of
and rum. I'm
seconds
like, so what? I'm drunk.
into the key cycle that a particular event occurs.
It's a
Is that
freaking
correct?
weekend, baby. I'm about to hit
In order to
me
properly
fun.
determine the location and the timing of a tech stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that tech stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a tech stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not
Okay.
determining that. I'm reading that from the text stream data.
Okay.
So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference.
But yes, if I had bad data, it wouldn't work. I don't understand this idea where he's almost saying like it's like he's almost trying to argue this is impossible. But there's no way that could not be. It couldn't be impossible. Yeah, he needs to ask him more directly and stop trying to lead him into it. Yeah. So.
There.
If you associate the wrong trip with the wrong key cycle, then your estimate of where.
That's correct. I guess that's where he needed to go. The wrong trip with the wrong key cycle. There we go. There we go. I think that's what he was trying to get at.
The text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because
How
it keys in
can
the
you?
key cycle with the event.
How can't you? I mean, you're
Let me
trying to
try
say
it a
it's
different way.
foolproof?
Your analysis or anyone's analysis and conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Patty, hold on here. I don't get what you mean. The Lexus can fly into space, according to this expert. Is that something he says later? Because I didn't hear that yet. What do you guys mean to the moon? I don't understand. The NT Karen Reed people love this guy. Yeah, because he's doing all right. He's holding his own. Unless he's not beating the shit out of him yet. So he's doing okay. So we'll see here. Just wait. You got to wait for it? Okay. Okay.
Pardon me?
Slide number.
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events.
Actually, can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was at key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So
But-
to answer your question, I got it at 1264.
So we can go back so we can see the 4 text stream events. I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that.
Are you saying there's no basis for the question? All right, I'm going to allow the question. And
This is yeah. Whoa!
You are aware.
Wow. She let him do it? Woo! I thought she was going to sustain that. But I think it's perfectly fine to ask that point. I think it's perfectly fine to ask that point. But yes, he's not aware of the statements the Commonwealth made because obviously the Commonwealth told him something different. Very good job by Alessi. And Bev actually allowed it to happen. You know, wow for Bev. Wow for Bev. Yeah, this is so let's see here.
That the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
so the objection is sustained. You need a foundation, Mr. Alessi.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with a Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them.
Okay.
And you
real quick, Eliza, yes, I did look this up. And I was able to find some documents. So here's the thing. Some of this stuff, and I think you guys need to understand this. This is a big thing here. Just because a court somewhere, like a trial court somewhere in America has said this guy sucks, is not precedential. It's important, and maybe they could do something with it, but it's not like the Supreme Court of Idaho has said this guy's a hack. That's important. So, but no, we'll go through this real quick here. I'd be happy to go through this with you real quick. This is a motion in limine from a trial court proceeding. So, this is a motion in limine. So, this is, oh, I don't know if this will let me draw on it or not, but there's a motion in limine orders, the court deciding. Elias says, oh my God, no, I'm not trying to, I'm just pointing out, guys, this is not like, these are not booyah kasha moments. Like, I can't walk into court. Like, if I'm them, if I'm Alessi, you know, I don't get to go in and like, booyah kasha. And be like, ladies and gentlemen, he's a faggot. And walk out the door. This is not that thing. I get it. I get, yes, he is a hack. He's been discredited. But there are, no. And I appreciate you guys being interested. But it's these things. It's kind of like that case last night people were all asking about. The appeals court said that Welcher was correct and the defense screwed up objecting to him. This one here is about excluding the testimony of Welcher. So it says, first is analysis of how this force affected the plaintiff's anatomy relies on a delta calculated by Carrie Alvino to determine the force. For the reasons said above, the calculation of delta V is unreliable, thereby rendering the whole underpinning of Welcher's analysis unreliable. Okay, so the problem is his testimony is built off another expert testimony here. Bev has declared him to be reliable, though. So that's not an issue here. We're not getting the same thing that happens. Yes, everybody hopes for a Brady Bunch moment. Yes, they do. And they say, second, the relevance of Welcher's opinion is questionable because analysis is not sufficiently tied to the facts of this accident. So they talk about here, we'll go into page 2 where it talks about him. They say, well, Welcher cites only one study involving a person of a similar age with similar pre-existing conditions to the plaintiff, though he doesn't identify the size of the tested individual. He does not identify the characteristics of any other individuals involved in the nearly 1,000 tests upon which he relies. In fact, Welcher's method of analyzing the impact of an accident on a particular individual by relying on how some impacts have affected people have been deemed unreliable by the Society of Automotive Engineers. Listen, I agree. These were all made by the team, but Bev said I'm allowing it. So this is the judge's discretion to determine how effective these experts are. And they say, finally, one of Welcher's opinions is based on cadaver testing, which is an unreliable method for analyzing how force affects live human beings. That's not a correct statement. We use cadaver testing all the time for that because it's the closest thing we can really do. So JD says this didn't happen in Massachusetts court. Doesn't happen if this happened in the court down the hallway. It's not binding on Bev. And unlike this other case, he does sound like he relies a lot on the data of this case. So this is not that thing, I guess, is what I'm just trying to tell you guys here. Do I agree with a lot of what's going on here? Yes. But Bev said no, he's okay. And the court's going to say it's an abuse of discretion, and she didn't abuse her discretion. Remember, the courts are going to say, oh, well. So it's not going to get overturned on this guy being in the case. So, Eliza, I appreciate you bringing it up because I do think it's important. You're not the only person who sent this to me today. But that's the thing with these cases. Like, if the Massachusetts Supreme Court had said, Judson Welcher's a bum, that's something. This isn't because he had the other expert got excluded, which makes sense. When domino 1 falls, domino 2 has to fall. So, yes, they booyah kachad witness number 1, which means witness number 2 had to step out as well. So that's all I would say there. Yeah. No, you're welcome. I appreciate it. Like I said, guys, I like law-splaining on the interwebs. I love doing it. I enjoy it. Because I think this helps you guys too in the future. When you're looking at a case somewhere, somebody says, hey, check this thing out. It's a booyah kacha moment. You're like, no, this isn't what it says. It's important to know this stuff. So I'm glad you guys brought it up. I'm not gonna sit here and yell at you to say who brought it up. I'm just glad you guys brought it up. So let's get back to this. Damn, I thought it was the first. It's always something to remember. When you ask a question, you're probably not the only person asking it, which is a good thing. That means that's why you should never be embarrassed to ask questions because someone else is probably thinking it as well. That's why there's no such thing as a dumb question. So is this a law channel? Yes, it's a law-based channel. Yes. Yes. So here we go. Here we go, chat. Let's keep going. Please explain a booyah kasha. Like, it's a mic drop. You get to pull your dick out and slap him in the face. It's a booyah kasha. Like, there is no flawless victory and you drop the mic and you walk out. Like, that stuff doesn't happen. And anytime, like, here's the big thing, chat, and this is something I've had to learn. Anytime you think you've got a flawless victory and you're like, oh, I get to walk in there and just fucking flop my nuts on the table. And the judge is going to go, oh my God, Sean, you're the best attorney ever. And everybody's going to be like, oh my God, this is amazing. He's the best attorney. You know what happens? You're completely fucking wrong. It's never what you think it is. So you always have to be careful because you think you've got that nut drop, and you don't have it. So you're never going to have that. Are these sex positions or acts? Well, so yeah, Albert Einstein's in the gallery, stands up and claps, and he tells me your goodwill was always hunting. You know, and everybody says, "Oh, Captain, my Captain," as I walk out the door. You know, it's don't you forget about me. Like, and I walk out in the parking lot of the courthouse. No, it never goes that way. It never goes that way. And if you think it's going to go that way, it never happens. You take about 5 minutes, you stop, and then you pull up another case, and you're like, oh, damn. So there's never any. It's just like watching Boondock Saints. There's never, like, bad TV is responsible for this. So there we go. My cat's name is Karen, says I love this channel. Yeah, well. So let's keep going.
You reviewed, you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It
Yes,
contained
Hillbilly Boy
where it had
Burgess.
been, and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
I'm going to see its sidebar on this.
To be fair, that was a good booyah to Alessi saying, well, if I read it beforehand, I would have had confirmation bias. But I think Alessi's trying to get to the idea of, do you agree that the first report was bullshit? And that would be I hope that happens because that'd be very soothing to hear that the first case was completely bullshit and Karen should have walked. At least that would be a nice dub to have in hindsight. But yeah, Alessi, I don't know what Bev's getting here. I think Bev is gonna, I think Hank is worried here, but we'll see. We'll see. So let's see what they're getting to. Paul's sitting here like, science men talk funny. Witness say he engineered, but I see no train. Paul confused. Where does he ride choo-choo? He did not ride choo-choo to court. Henry H., do I think Alessi's taking too long to ask a question? No. I just think he's trying to, he needs to cut to the chase a lot more, I think. But I understand what he's doing. Good question, though. All right, hold on here. That John DePetro guy keeps getting into court every fucking day. How does he do this? Also, I don't see Vinnie Politan or anybody out there, so that sucks. Oh, wow. This thing about Trooper Paul is, whoo, this is going on, chat. God, I'd love to read the transcript of this sidebar. Okay. Oh, the lottery's for the whole week? Oh, I thought it was just every day.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So just 2 words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation
Yes,
and
I'll
your
talk
Hold on,
about
Mr.
later.
Leslie, court reporter copy.
Thank you. I will.
Whoop, 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 whoop.
That's again, the question is coming.
Whoop, whoop.
Can I-
That's the sound of the
my
police.
question?
Ask a,
Whoop, whoop.
it's an appropriate question, Mr. Rule.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor.
You have to remove part of that.
Okay, understood, Your Honor.
Good objection
Do
by
you
Hank. I think that's
know
fair. Fair
whether
ruling.
there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
Oh,
Ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher,
wow. Wow, Bev just told Hank to go fuck himself. Wow. Yeah. John was killed by 2 huge freaking guys. What if there's one guy with 6 guns, though, Eric?
in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
Oh. Oh, Hank is a little, he doesn't like this. Hank doesn't like this. Robin Hood saying sis gun, why that would be a ranger, sir. No, we're Boondock Saints reference. Yeah. Where you going, pal? Fuck nowhere. Yeah, you get hit in the head like, nah. You get hit in the head like, nah. But no, I understand why Hank is doing this. Yeah, is there any plumbing pieces? Yes. So, okay, let's see here. Is this where Hank asked for a mistrial? I don't think Hank would ask for a mistrial. I think he thinks he's winning. Asking for a mistrial would be dumb. That'd be very, very dumb. If I'm Hank. And then Maddie asked, do we get the sidebar transcripts? Yes, those are part of the, let me pause here to make sense. So when you're reading a normal, hold on here. Okay, we're gonna take a screenshot here of a transcript. Okay. So, here's kind of what a okay, so when I get transcripts from court reporters, like I'm waiting on one coming up, it's gonna come in as a PDF because screw using paper. Because I can control F my way through things. But let's say there's a sidebar, like this is open testimony here, okay? If there was a sidebar, Your Honor, may we approach, I'd like to discuss this on the record at a sidebar. And it would say, outside the presence of the jury, a discussion was held on the record. And then this part would be bop, 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 bop. And then the jury has now been reconvened and we're back in open, and it says back in open court. And now from there. So I hope that makes sense. This will get denoted as being outside the presence of the jury. But then the rest of it will denote we're back on the record in front of the jury. I hope that makes sense. So yes, this will be part of the entire transcript. I hope that works. I hope that works there. Digital voices, transcripts, and PDF files. What about trial number 1? Are those still sealed? I don't know yet. But, and Shinny, I'm talking about when the case is over. Like, let's say Karen gets convicted and then there's the appeal. Those get inserted into the record. Okay? Those are the official transcripts of the official record. Like, that's what I'm trying to tell you. Like, right now, we don't get to see them, but those will become part of the official thing. So, like, this trial I'm going to do an appeal on. All the out of court discussions, because in this courtroom, they have to go into the judge's chambers because there's nowhere to do it. All this stuff is done outside the presence of the jury, but it's denoted. And yes, all these sidebar discussions will look like that too in Karen's case. What about trial 1? Those are still sealed. Yeah, that's all still impounded. What if there's a mistrial? Those would get impounded again. And then it would be, if the case gets continued after that, then they'll stay impounded. But if they dismiss it, then that would become available to us. Doesn't the defense ask for dismissal of the case after the Commonwealth rests? Yes, but that's not where we're at right now. We're not at the end of the case. We're not for the directed verdict yet. If there's ever a mistrial, like, guys, I don't even know what Hank's asking for. I don't think Hank would ask for a mistrial at this point. So I don't know where you guys have got this idea. They would try her again. They aren't going to fucking quit. I don't think that happened. That's why somebody brought it up. No, we can't see the trial 1 transcripts yet. She can impound them till the case is over. So, how do you rate this witness performance so far? He's doing better than Alessi. So, just telling you guys, just being honest. He's winning right now. It's a 10-9 round. It's not a 10-8 round yet, but Alessi is not scoring the hits he needs to score, in my opinion. So, let's get back to this, chat. Let's get back to this. So, wow, they are still going at it. Go back to the objection where Bev tells him no, and he says, he does? Hold on here. I didn't hear that. Where does he do that? In here? Okay, hold on. If he did that in front of the jury, that's really bad.
There to be for a hypothesis for the time of the impact at 34 Fairview.
Objection.
I'm going to see you again, folks. I'm sorry.
Okay, there wasn't a mistrial there. Where are you talking about, Johnny? That wasn't a mistrial there. Turn the volume up. It's all the way up. Let me...
In this case.
Stand.
For the impact alleged to have occurred at 34 Fairview.
Objection.
Sustain.
I'm going to ask for an instruction.
He's asking for an instruction, not a mistrial. He's asking for an instruction. I get because it's a little fast in his accent. He's asking for Bev to do an instruction, and she says, fuck you, I'm not doing it right now. That's what they were asking for. Instruction, not mistrial, chat. So. All right, let's see here. Do we... All right, here we go. I think this is it.
I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we...
That's attorney speak for, fuck, I can't ask that question. We got to move on. So.
discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir?
Sure.
Is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need to?
I do. If you, sir, could turn to page 9 of your report.
Sure.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of and I think you're referring to Mr. O'Keefe's medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
You did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I want to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration.
Okay.
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sort you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, we're going to do that. We need to do it with the court's permission. So
Sorry.
if you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principles down first.
I remember when I was a kid, I had blackjack on my graphing calculator. So I wonder if he's got blackjack on there.
So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay.
Do they run Doom? No.
And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you
Wow.
discuss your experiment
Wow.
where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 Gs of force.
That's what we actually measured
Right.
in the
And
test.
can you tell the jury what is meant by Gs?
So G's is a measure of acceleration. If you take usually acceleration is measured in feet per second square.
Yeah, I was gonna say, guys, like, if we watch Formula One, you see when the car goes to the corner, it talks about the G force being put on somebody, or like fighter planes, you pull like 5 Gs, or like in Top Gun, they went into a 4G negative pushover, a negative 4G pushover. A G force is what you could. It's the force of gravity, and that's why like that's not an uncommon thing. Or you hear like the G limiter. If you guys watch people like, planes flying and they're turning real hard, and all the freaking air, the moisture is condensing off of them. G force is a thing. Like that's not like I get it. Yeah. Well, the G unit. No, but Golden Manga says how many G? Like, okay, joking aside, impacts can have a lot of fucking G forces in them. Car crashes are really fucking rough. So, I mean, is that like the G spot? No, it's not like the G spot, you guys. Yes, the fall doesn't kill you, the immediate stop does. Yes, Dewey's saying the Spanish Grand Prix this weekend. I like the Circuit de Catalunya. Yes, it is good. So,
If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in Gs. People often heard about fighter pilots losing consciousness at 6 or 7 Gs. Basically, because your blood's getting sucked away from your head.
Okay, so he answered it. Yes. The blood's not getting sucked away from your head. It's getting forced down and pooling in your body. It's not getting sucked away. But fine. You get the one there.
Head, not because you're being impacted. But G forces, or Gs as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous.
But remember, chat, when they did that dropping of the dummy, that dummy's falling at just free fall. It's not, there's no there's no external acceleration. It's merely free fall. So I don't understand. Yeah.
Unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand, you go to scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,000.
See, now that's the problem. These guys are both antagonistic at each other. So, but I hope, is this going to lead to something here? Because I don't know where Alessi's going right now. Like, let's see what Alessi's getting to. I hope this is something important. Yes, these are the world's smallest whippets. They're acrylic whippets.
634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at.
There we go. You support Dr. Wolf, therefore Karen Reed's not guilty. That's reasonable doubt. Thank you, guys. Pack your bags. We should all be able to go home from here. Sadly, we won't. But that is reasonable doubt, in my opinion. So, yeah.
Manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
Okay, time out. Okay, Snoop, you're a science guy. Apparently you're a science. Ag, you're super fucking sciencey here. Yeah, the coefficient of... Okay, and this is where I'm going to throw out my physics. This is about the all-knowing physics. Mu, the coefficient of friction. Yes, a higher coefficient of friction decreases the ability at which you can accelerate. You want the lowest coefficient of friction ever. So yes, the surface you're accelerating on can greatly determine the force you can impart. Like, I don't understand. Yeah, it's not a clear statement. I think Alessi asked a really shitty question. But yes, I mean, like, I'm not a science guy, and I think a lot of people on the jury would say, well, yeah, the surface you're on would determine acceleration. So, if there's any sort of big brain stuff, do they have to be prepared and submit earlier? There might be times where they could demonstrate on a board, but Alessi's not going to let him get up there and demonstrate on a whiteboard unless he wants something. But if this was on direct, he could have done that. Hank would have let him do that. So it's a shitty question, yeah. I think he means hitting something hard in the head decelerates the head fast equals more braking. I agree, but this is this doesn't make sense.
Impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents.
Okay, and after that, and Alessi just moving on doesn't seem to... That's not going to make you look credible, yeah. This makes him look credible and makes Alessi look like he's just bouncing around. I don't like this. This is poorly done by Alessi.
In their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Would Jackson be a
Number
better fit
25?
for this witness?
That's what I
No,
think
he's
it is.
not
I just wanna
science
check the
guy.
report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the,
He's not going to let you
that's
put
it,
your
number
security
25.
blanket on.
We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Can the witness see the document being referred
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Alessi?
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you.
That's sloppy. That's sloppy by Alessi. Not impressed. Not impressed with Alessi on that one.
Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you. So I'll repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Yeah, okay, so now Alessi's bolting him down. This guy's getting very overconfident. He needs to be careful. I don't know why he's getting this cocky here. Because Alessi's setting him up. Okay, yeah, this part makes the witness look like an asshole. So, here we go. This is actually getting good, chat. Let's see here.
Did you mention that on your testimony on
I
direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old. Therefore, if I did the math correct, right?
That sounds correct.
Are you
1979? 1979? What do you mean I'm jumping all over? I don't get. What do you mean am I jumping all over? I don't get it. I don't know what you mean. Ooh. It's a fucking, hold on here. That's 47-year-old report. 47-year-old report? A 47-year-old study? You know, we've had 47 years of trauma medicine. 47 years of this is older than Wolf. Dr. Wolf's been a neurosurgeon. Decades of neurosurgery, trauma treatment. We've fought multiple wars in that time, which have increased trauma medicine and first response. You know, cardiology, pulmonology, you know, orthopedics. 40 years of engineering. Like I said, chat, you know, cars back in the 70s like had front ends like this where the wheels were. Nowadays, what do cars look like? They're sloped and they have low front ends. Why? So people don't get killed and put underneath the car. You know, they go up over the car or they get shot off the car in a different direction so they don't die. Like all kinds of things have changed. This dude's profession has changed since 1979. That is hack level shit right there. And that nobody's done an update to it. Cars are different. Everything's different. Wow. Wow. I've not jumped in many years. Funny. Yeah, even I commented that slide look old. Yeah, it did, but I figured it was kind of one of those ones where it's like, if you had the tables for like, you know, the fall of gravity rate, like the things in free fall per like 10 meters, you know, and like that was the chart, I'd be like, okay, well, yeah, you don't need to re-update that all the time. But yeah, that's ridiculous. So 46, damn it. Okay, well, I think I know when somebody was born. Let's see here. Back in 1979, didn't all cars have seatbelts? Well, by then, newly manufactured ones, yes. Ralph Nader got his thing there. So, so Aperture's an old boys club, yeah. Yes, European cars have longer front ends for their standards and the space between the engine and hood. Yep. Yep. Crash testing has changed so much. So yeah, 1979 is Burgess started his bachelor's degree. Yes. So this is just ridiculous. This is their strong. This is okay. This is interesting. All right, here we go, chat.
Aware that given advancements in science since 1979, advancements in medicine,
There we go, Alessi.
advancements in
Bam! This is good. Now this is good. Now we're hitting it. Score some points, Alessi. Here we go.
technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities.
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you
But your theory is not that he smacked his head into the hood or window or any part of the car. That's not part of your theory. Your theory is that that didn't happen. So why are you talking about it? Yeah, he's using an old study and he's not surprised it's inaccurate. Go out and do. Why doesn't the scientist go out and do science and do a new study? So, yeah.
would agree that as of January,
Also, does Alexis in this case have that when you're backing up? I assume it would because it's a fucking Lexus. But like that backup sensor, does it have one of those? I don't know. Did we know? Does anybody actually know that? Huh. Yeah, his theory is he smacked his eye, but remember, there's no serious like it's not that bad there. So
2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities.
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Maybe that's about a source.
I'll allow the question.
So
Yeah.
I'd want to see the data. Again, most cars, for
yeah, I think this is wow, and he's not going on it. Yeah. Unless he's just kind of letting us go away.
example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mhm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis.
Exactly. Make him look out of date. And he just did that. You didn't check. Don't you think that would have made a lot of sense? Yeah. This is good by Alessi. There's more he could do, and I'm hoping he hits on this more. We got 4 more hours of this shit.
That we went through. Force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me 2 questions. You said instead of, so that's no, it's not instead of. They're 2 completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I don't know if I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height.
So, yep.
Where was it? It was you. Was it you in that slide?
It was.
Where were your feet?
On the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground to the top for the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do either one of those.
So the point is, it's certainly possible that if there's 4 to 5.
Very scientific-y, Mr. Science Man. You didn't do it per the actual situation. So sciencey. Wow, this guy really is Reddit tier. Their science doesn't account for the actual, battlefield this occurred on. The actual scene. Good job, science guys. Yeah, I don't know how the impact happened. So what the fuck? If you don't know how the impact happened, why are you here? Eaton asks, whoever said Lexus was on the berm. It would have been right there. Turtle Boy ran up in the yard. I think it's very likely Karen Reed ran up on the berm. That makes the most sense. Yeah, he just assumed John was in the road. Yeah. This is awful. This is garbage.
More inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head would be?
You don't know any of that either. He could have done a million things. If that happened, he ducks his head if a battalion of Chinese paratroopers is falling out of the sky. I mean, if the car jumps up high and he lowers his head, the thing doesn't even hit him. Like, if he lowers his head, why is he lowering his head? You didn't lower your head when you spun away. Your head stayed straight. Remember, you did your gay little pirouette and you got paint all over your arms. Remember that one, buddy? You didn't turn your head. You just spun off like, woo. This doesn't work. Yeah, he's not insisting upon a likely scenario. So, don't the tire sensors tell she hit a curb? No, not necessarily. Said to encourage scream, I'm going to holler. This is just getting retarded. This is not science. This is not science at all, chat. Not at all science.
Yeah, as I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do.
If you don't know, then why'd you do it at all? If you don't know how it happened, why did you do a demonstrative aid that doesn't support the theories because you don't have enough information? This right here, Bev should strike all that shit he presented. Right now, hold on one second. Right now, she should literally strike all of that because he's clearly not demonstrating anything. So that was all conjecture then. He was just showing it was possible. Well, that's not his job. Yeah, the car could have hit John. Sure, it's possible. That's not the standard. So this is not this is nonsense. This is Fauci level science. Yes, the whole idea is John O'Keefe got hit by a car. Here's how it happened. Here's what we could show you. The guy's like, I don't even know how it happened. Which means I don't know that it happened at all. I am the bachelor's degree.
Do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where.
Booyah! That's correct. Now look at him. He's all fucking mad. But you don't have an answer because you don't know. It was done properly. How do you know it was done properly? You don't know that it was done properly. You don't have information. You started with the hypothesis that he got hit by a car, and you fit things to work there.
Conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was.
You don't have any information. You have no real information to rely on right now. There's no information to rely on. Absolute. I want a crumb of information, sir. A crumb.
I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that thing because you don't have information that you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely consider the berm. And The second question, when I
You
presented
didn't-
to the jury,
No,
when
no,
I mentioned the berm, when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way.
Wow. 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 Luke saying, I do think what Alessi needs to do is get him to concede that for this to work, John needs to be on the road. And then you can context your way to victory saying, why the fuck would he get in the road? Yeah. He does have info. He doesn't have enough info. So that at this point, he has no info. He has snapshots of info, but he doesn't have info for the moment this happened. So he has no info. I get what you're saying here. But okay. Yeah, unless he needs to be driving that home. Okay. It's all about interpretation. Fair enough. $4 a pound says, why is this guy even testifying? I don't know. I don't know.
When we were talking not about finding a shoe in the snow, and you mentioned a berm,
Mhm.
I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
That's a booyah moment right there.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
It doesn't
I
show
could probably
that.
find the slide for you.
So you didn't do a force analysis to determine how much force would be applying assuming a contact with the right eye, did you?
That's correct.
And force
Ooh.
analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what.
Part of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
Mr. Alessi, why don't we break you?
Exactly. He did not paint his face. We have no knowledge if the head actually hit the car. You know why he didn't want to do that? Because it would really hurt. It's the same reason why he didn't do this at speed. Because, oh my God, I don't want to get hurt. If that car hit him at 20 miles an hour, his arm would break. He probably would have broke his shoulder. So, yes, this guy is a hack. A hack. Who's winning right now? He is unless he's gaining, but from earlier, God, guys, this was a disaster. This was a disaster from earlier. So, I mean, unless he's making points, but he's still behind. Unless he's still losing. So, yes, Unhung Hero says everything this guy said is bullshit. Thank you. Auto Doctor saying, I don't think Judson did a good job of even convincing me the collision was possible because the injuries and damage to the car, which was proved to happen. But now, unless he's making him look good. And that was from a little while ago. Yes, but now he's bouncing back. He's bouncing back. So. Scorgon Hammer says, imagine Sean dying to prove the analysis. Well, the point is that if that's the case, then John would have died when he got hit, is the point. There's a reason why he didn't get hit at 20 miles an hour. A 20 mile an hour hit by a car is very likely going to be possibly fatal, if not life-altering injuries. It's the same reason why you can die falling off your roof. A 10-foot fall can kill you. Getting hit by 20 miles an hour, that can kill you too. Dirk Diggler says, glancing hit to the arm dies. Well, remember, it wouldn't have been a glancing hit to the arm. Remember, we talked about this last night. The way he was standing was allowing him to avoid damage. He didn't want to get hit by the car. This guy pussed out. Let's see here. Yeah. Like you said, John had a ground of the force of 486 Gs. Yeah. How high to hit the ground at 20 miles an hour? Yeah. He's defining glancing weird. Spuggan says, I get hit by a car at 20 miles an hour, broke my leg. Not surprising at all. Snoop is saying, I'm okay. The point is, generally speaking, I think we could all agree if a car hits somebody going 20 miles an hour, that's going to be fatal or severely injuring. Just like there's some things out there. I think we could all agree. Why are you careful going up on a roof? Because you could get paralyzed or die if you fell off. That's the logical conclusion. Getting hit by a car going 20 miles an hour could still fucking kill you, or it will really fuck you up. I think we can all agree, Snoop. So that's what we're doing here. You know, écoutez les enfants. Écoutez. I'm just trying to point that out here. Brandon saying, I think John was on the road. He stepped on the road through the glass of Karen Reed, lost his balance, and fell backward. She backed up to see what happened and saw nothing because he was already on the ground. I buy it. That could happen. Who knows? Who knows? So, Go says, good day. Well, hello. Yeah, he talked 3 different ways out of his own ass. Has this guy gone outer space yet? I haven't heard that yet. I was hoping we'd hear that. They had a nerd fight. No, this is actually doing a good thing here. Unless he started whooping his ass, but it took forever to get it happening. So, let's see here. Do I have any other comments to try to catch up on? Azure and Fish says, is Brennan allowed to talk to Welcher during testimony? No. When your witness is on the stand, that's it. And that even means if you take the day off and you come back tomorrow, until their testimony is over, nobody can talk to them. Now, Hank could say, hey, Judson, show up tomorrow at 9 a.m. We'll let you in the back door or whatever. That, or we'll have a ride come pick you up. You know, or, hey, did you see the Red Sox game last night? They can't talk to him about his testimony. You can't. Not allowed. Not allowed at all. Is it improper for Brennan to travel from court in the same car? No, that wouldn't be improper. That would be perfectly fine. They can have lunch together. Although, if this guy's at all smart and they're trained to do this, you go fuck off somewhere else and you try to separate to avoid the appearance of problems. Carolyn says, make an apology video for defending Nick Ricade and his family. Ha! Cute. No. Never. Let's see here. Unless he's using his autism against him, I get it. Yeah, well, we'll see how well it keeps going here, Chad. I'm not, like I said, I'm getting concerned. I'm getting very concerned. I just don't think this is what Alexi's gonna have to yank it out of his ass here coming up. So didn't totally pick this guy up though, or whatever it was. Yeah, he's allowed to pick people up. That's not a problem. So yeah, it's still not enough yet, chat. If this ended right now, this is the disaster for Karen. And I don't feel like this is going to turn around. I mean, this is turning into a disaster for Karen. Because remember, if this is falling apart. This is falling apart. So, because this sets a scene for Arca. So, people in court says, wait, do you really think that? I mean, it could be any million number of things. Who knows? Who knows what they did? I don't know if the police planted evidence or what they did. Who knows? It's so fucked up we can't trust it. Dirk Diggler says, John O'Keefe is beaten and bitten by a dog. I don't buy that there was an assassination so Brian Higgins could sniff Karen's puss. I don't buy that. It doesn't make any sense. So there we go. That's all I'm just trying to get out there. A 20-mile-an-hour collision that is glancing could easily not kill you. That's not what happened here, though. Is like if John is ejected, like they're saying, he wasn't like he would have had to have been hit severely, and then there's no marks to indicate a severe hit. They have not mentioned a glancing blow until just now. He never mentioned really glancing until, I mean, this is really kind of like the beginning of it here in a severe manner. I don't believe John was hit by a car. They can't prove it. So this is the sloppiest case ever. Super slop. So let's keep going.
Thank you, Your Honor.
So jurors, your lunch is here. We'll see you.
Right, the jury.
Okay.
You can get.
Oh, there we go. Here we go.
Go ahead, Mr. Leslie, whenever you're ready.
Just take a moment, Your Honor, to reorient. I'll be right.
When did he say this? I don't recall when he said this. He literally said John O'Keefe's likely hit by the car as the car is shooting into space. When does he say that? I don't recall when that happens, or does that not happen till later?
Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Well, you guys spoiled it for me then, damn it!
We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on
bones
any
are on
bone.
the inside.
Sir, if I could finish my question, please.
Okay.
You can
It's all good,
conduct
Mike. Don't worry.
a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces
If you don't know how much force was applied, then how do you know he spun around like that?
on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm, is from the shoulder down to the tip of the fingers, is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right. Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue on together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of having holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish.
Okay, guys, some of you are wondering, they talked to Wolf and Rentschler. This part here, Wolf and Rentschler really guided them along on this. They told him to do this.
What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay.
Tell me what you're ready to say.
Go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for the impact window.
All right, let's go, math boy. Science, bitch. Also, chat real quick. In honor of National Hamburger Day, this one's for you.
Okay. Question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through simple mathematical semi-algebraic application of the numbers, correct? You
Correct.
divide,
We're doing a little simplification in terms of the crash
Yeah.
pulse shape, but generally, yes.
right. So but
They're
let's take
talking
the
nerdies
conservative
to
number,
each
the
other.
lower number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force the F you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to
No.
do your calculation? I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
The metacarpals, and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone?
And this is and I think he's trying to play stupid here, but he has to know he knows these ARCA guys aren't fucking tards. He knows the ARCA guys aren't tards here.
Bone in the hand. Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I don't know if I don't know if I buy that. 300 to 400 pounds of force is a lot of force. So that doesn't make much sense to me. They put the fries in the bag? Yes, they did.
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
The way he did it, the thing hits your hand directly. It's a direct on hit to the hand. I don't know how much more concentrated it can be. It hit the hand in its entirety. Remember, he was holding the glass and the whole car hit that. So I don't know how he can make this argument.
Depends on what you're hitting, what it's made out of.
The
Contact
Lexus
area.
SUV. Let's assume, I'm sorry.
So let's, can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV,
Mhm.
right?
Yeah, he's using words weirdly again. Yeah, this is it's a guy who doesn't want to admit, yeah, it's possible like this guy would have got fucked up. There's a reason why he didn't subject himself to that level of force. There's a reason why Judson Welcher didn't subject himself to that level of force in the parking lot.
Back up. You don't know where exactly, under your theory, that there was contact. You don't know, you testified to on direct, you don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, right?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking this is possible.
Anything is possible. I don't deal in possibilities. I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was.
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear taillight area.
So your assumption is that that because there's a taillight that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are taillight fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir, and you're going to move.
non-responsive. What part of the goddamn body broke the taillight, you fucker?
Strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making
And that's because we already know it's there.
assumptions. You're taking what you view to be certain data, and you're coming to a conclusion. But that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the taillight at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone.
See, Evil Ghost, I don't buy that. Because the only way it would work is if the hand broke the tail light. Because immediately his body pivots into it. But I don't see how this hitting and then your forearm going, it's not his elbow. It's the forearm. Like, I don't see how he... Yeah, there's no way there could be anything else. The part with the paint broken, I don't see how he has enough force there. Because if he's pivoting that hard, the amount of G-force this guy would have had, he would have smashed his whole fucking body up on the side of the car and smashed his ribs apart. I don't see how that, I just don't buy it. And I guess, I don't know. Anyways, let's keep going.
In the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone?
We actually have some charts and
So,
graphs here in a second, chat.
Depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading. You will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight, Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers, okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So you got above 350.
300.
Above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was it? You said
2,188.
dyslexic? Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear it.
You came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay, so let's go with your number of force from this vehicle of
1488.
2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Look at this.
Sure. So somewhere between 2,500, the one
We'll talk about
cadaver
this
tested a
later.
distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point.
Okay, now he's just making excuses. We're talking about a goddamn car hitting somebody. The entire backside of a car hitting a guy's hand. We're not talking about pencils. We're not talking about your needle wiener. We're talking about the backside of a car. We're talking about the backside of a car, sir. Yeah, this is just ridiculous. It just I don't get it. I don't got it. I don't get it. I mean, this is, hold on here, guys, chat. We're going to pull up this picture. Remember, this guy's like, well, I could shove my pencil through my hand. If I'm a lessee, I just show this picture here. I just show this picture here. Sir, this is what we're talking about. This level of force. Well, golly by golly, I don't know what we're talking about. How about when your hands smack up against the fucking back of a Lexus LX 450? How about that, you son of a bitch? Yeah, he's using acceleration to also explain pressure. But yeah, here we go. Here we go. Like, explain it in this context, you shill. Prove it. Let's go, science man. Eric says, why doesn't she control her quarter? No, Alessi is trying to cut this guy's balls off. She has to allow this. This is good. But this right here, why aren't we demonstrating here, sir? If I'm Alessi, they should have put this up on the screen. Do this calculation. Because that's a pretty blunt, directed calculation. That is a very directed, look at it. It's distributed evenly across the back side of the hand. It's distributed evenly. Notice that. It goes along the whole back side of the hand. And I hope there's people out there looking at this saying, this guy doesn't always talk about. Sure, but this is an even distributed force. So all of his nonsense here doesn't work. This is all garbage. Yes, they are on cross right now. Alessi's got him on cross. Is the fact it's not a fixed object matter? No. That's part of the like biomechanics. Yeah, this is Alessi's now scoring points. So here we go. If I'm Alessi, I would have put that picture up and said, fine, this is your own fucking handiwork. Show me. And he says, I can't tell. It's like, then why did you do this? You guys, like I said, you guys want some booyah kacha moments. Make him question his own work. And then if he can't, that's the booyah. If I was Alessi, I'd walk up and just fuck right through his hand. So. Oh, that was a spurg out that last little. That was some stimming right there. That was some stimming. Say, I'm way out of my element. How was I out of my element? How was I out of my element there? Like, just tell me how I'm out of my element here. I don't understand. What part did I get wrong? Because the argument he's making is, like that is there. Did I play the video and not share it? I backed it up. Sorry, chat. He's got Asperger's. A lot of engineers have autism. But how am I out of my element here? You're not arguing the force versus area thing backwards. Okay, well, so I'm no different than this guy, and he's the PhD. If he's retarded, guess what? It makes sense for me. I'm not the expert. This guy's the tardo. So let's get back to what Alessi talks about here.
Disagree with that.
Here we go.
cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question is too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load in a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed. But what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of
There we go. Alessi's got him. Alessi's got him. That's how you get him, Alessi. I'm not talking about your hand, honey. I'm not talking about the desk. I'm not talking about a pen. I'm talking about a fucking car, the one you tested. Oh, he just had a honey moment here.
6,000 pounds. Is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper, potentially, yeah. But from a taillight or a broad flat surface, no.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Well, and that's my point. It's a 7,000-pound car going 24 miles an hour. That's a lot of momentum coming down the road. That's a lot of kinetic energy that gets imported into your hand. Yeah, that is thousands of pounds of force. Or yeah, how about a hammer? It's flat, yeah. But still, chat, I think this is important here. This thing is critical. He's arguing there's no way this mass going 24 miles per hour would fucking break your hand. Bullshit. Bullshit. Remember, he only did it 2 miles an hour. So,
your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the taillight.
Okay, what we're going to do.
Wait. Hitting the exhaust pipe? You're telling me hitting the tailpipe is more likely to injure me? Like, nah. I don't buy that. I don't buy that. Buy that. I don't buy that. Buy that. I think he's full of crap. Yeah. Yeah, on direct, the taillight explodes at 8 miles an hour, and now this guy's fisting tailpipes. Yeah. This doesn't make any sense. This doesn't make any sense, chat. Remember, this guy thinks that the taillight in your car is an anti-personnel mine.
Sorry. Mr. Will, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Leslie?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes. You have one of just the rear gate. The one measuring the height. Maybe. There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there, could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to
I hope I'm less competent. I'm not a scientist. I don't have scientific training. I'm not a PhD. I hope I'm less competent than him. You're like saying, oh my God, Sean, you're more retarded than Alessi. I hope so. I'm more retarded than Welcher. I really hope so. Because God almighty, if I'm more smart, if I'm smarter than these engineers, we're dead as a society.
400, let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is a number I calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that
I'm sorry, what, to the hand?
to-
Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes. Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep
sorry,
track.
Your Honor. Yes, Mr. Wolf. Yes,
All right, thank you.
thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No,
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records, in the autopsy that you say you reviewed, of any fracture of any bone anywhere in the body of Mr. O'Keefe,
Yes.
other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of it?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there'd be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture.
Ah! Ah! I love this. I love this Alessi running wild through the streets, chat. Now we're getting somewhere. Now we're getting somewhere.
To a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I need you to prove my question.
You're asking me about the opinion of a medical examiner. I'm not a medical.
Only one.
Yeah, this is where Alessi's like, shut the fuck up. This is now he's getting lippy. Alessi's got him pissed off. Alessi's got him pissed off right now. Listen to him trying to lip off at Alessi. This is where you go, sir, I haven't asked you a question. This man is upset now. This man is mauling just a little bit.
You're asking me about the opinion of a medical examiner. I'm not a medical.
Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for medical
I
reporting.
understand. I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record or autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Boom! 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 That's a kill right there. That's good work. And imagine, like, he did so much crap at the beginning. This is actually good stuff. It's been diminished by all the garbage from the beginning. That's the problem here. Alessi screwed up earlier so bad. Yeah. This is ruining this.
Do you understand?
We've got to be getting to the... I'm surprised. I think Alessi's going to be done. I think he's getting to the end. I think he's getting to the end here. Scorpio saying he didn't what? He didn't what, Sean? You think he did a good job at the beginning? He did awful at the beginning. But here we go.
Whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scordy Bello, in the conclusion she reached in the autopsy report that you read. Did you read the conclusions of Dr. Scordy Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scordy Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
What? No, that's that. He said he read all that stuff. If you're telling me like he needs to know the injuries John O'Keefe suffered to help make his biomechanical analysis. This is critical information. And remember, he's got all this medical training. He took these classes where you go sit there and finger dead chicks in the cadaver lab or whatever it is he did for fun. You know, like, yeah, this is. Yeah, Strayance, if you can't prove he got hit, it doesn't matter what the fuck the phone did. You're focused on the bigger thing here. Who killed him? And if it's not Karen, then who was it? You're worried about the wrong thing here, brother. But no, he should be allowed to testify to this. No, he said, I probably read her report. He said probably. Well, what do you think he did at the cadaver lab? Am I having calculus flashbacks? No, I got pre-calc. Calculus kicked my ass, homie. There's a reason why I took some ghetto math in college. I was not. No, I don't do calculus. When you start putting letters in things, it gives me problems. You know, math with letters in it is not real math. The cadaver stuff? Well, I don't know what he did. They say lawyers don't do math. We don't. There's a reason why. There's a reason why I'm not an engineer. When my dad told me at one point, I was probably about 10 years ago now. Actually, yeah. He's like, I always thought you'd be great at, my dad thought I'd be great as a doctor because I really like to help people. And then he said, once you got to like high school and your math wasn't so good, I realized that probably wasn't going to happen. So my dad's like, he's like, that's a shame because he's like, I think you'd be a great doctor, for the way you care for people. And I was like, well, thanks, Dad. But yeah.
Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint exercise.
Okay, here we go. I'm looking forward to this. My dad told him, son, you can eat any sandwich you want if you put your mind to it. Yes. He was calling you soft. No, I don't think so. Trent says that's the nicest you're retarded I've ever heard. Oh, funny. Gina's saying, I bet the jury doesn't even address this in deliberations. Yeah, I mean, it's possible. Who knows? There's a standoff in Ohio. Ooh, well, I mean, Ohio man doing Ohio things. And no strays ENT. Or no strays ENT. Says, so Leslie wants to address everything except the data shows her car is reversing 24 miles an hour. At the same time, John's phone stops moving. Well, yeah, because if you can't prove that she hit him and there's no evidence she hit him, it doesn't matter what happened. You have to, it's not like there's a bullet hole where you could say he was shot. There's no clear way this guy has injuries indicating a vehicular accident. So it's kind of a big deal. Yes, Jared's posted, sir, put the science in the bag. Island saying, unless he's fumbling around, but Welcher's terribly unlikable. It's subjective, which is worse, especially if the jury gets lost in the word salad. Yes, I agree. And this is from a little while ago, but I think we're it's about 20 minutes ago from Island, but I think things have changed. Jefferson says, does it matter if the good stuff was after lunch? I don't know. Jesus Loves You for $5 says, did you get to the part where he admits they have no idea when John was hit? I don't think specifically, but I mean, it's kind of understood. But thank you for the super chat. Thanks for being here. Jesus Loves You. It's been a little while. Stephen Cooper says, Dr. Sean Kevorkian. Oh. I would leave a sandwich at a patient after a surgery. Well, I can see that happening. I can see that happening. I could have gone into phys ed, Sean. Yeah. That means I'd have to have been a teacher. There's no way I could have been a teacher. I would have necked myself. Mystery Sniper says, just remember, he's proud of you. I like to think he is, for the most part. You know, this stuff, probably not. But the actual things I do in life, I'm sure he's proud. J-Rex says, your dad was saying you're fat. Well, that too, probably. Oh, so let's keep going. Yeah, I'd be a history teacher, but I'd be like, I don't know if I'd be the best at it.
You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise. And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise. It's a test.
Okay. You want to call it a blue paint test?
Sure.
Okay. Let's call it blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okay.
So your blue paint test involved painting the right rear taillight blue, correct?
Correct.
Positioning the test subject behind the taillight, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that, okay?
Oh, how dare we not do this at the exact...
Now,
Your
you conduct that test
bastardization of it, sir.
in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm.
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mhm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you?
Of course.
Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have.
What? Unless he asks the question I've been hoping he'd ask. Why not, though? Because I don't want to get fucking killed. But wait, I thought it was just a glancing blow, Doctor. Actually, I thought it was a glancing blow. I think he realizes how retarded this 2 mile an hour thing sounds now.
Done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You could have done that.
If you use the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So then why did you do that test? Why did you do this test then? If you don't have enough information or any information you can use, why did you do this test? Wow. Wow. Wow, chat. Wow. Holy Jesus. No, Brittany, it's because he would need he would need to have like 1,000 of these cars and keep smacking them into a crash test dummy. Although it's funny because if the theory is that these were glancing blows, John caused no damage. Wait, hold on. Even better argument, Chad. Even better argument here. Hear me out. He says I'd be ruining the cars by doing that. All you'd be doing is smashing out the taillight. The rest of the car is perfectly fine. So why wouldn't you just do that? Or are you telling me that very likely John would have caused even more damage and actually hit the car? Wow, he just admitted to it. Click this and put it on the internet, chat. He just admitted, yeah, this would have happened. Because at 20 miles an hour, John would have smashed that car apart. I am a genius. That's a big freaking point that he just admitted. That's a big point. I hope the defense watches this. That ain't happening. Unless Alessi gets to it. Yeah, 25, you'll suffer like body panel damage. You're replacing the bumper on the back of that car. You're replacing everything. But there's a reason why you didn't strike it with a crash test dummy, because it would have destroyed the car. I thought it was only going to break the window. Could you do that, Mr. Science Man? Oh. Wow. There's plenty of time for Alessi to get to it. Well, here we go.
Are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So, your assumption, as I understand it,
Thank you, Scorpio. Yes.
24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis.
No.
Yes.
There is not one single slide I have
Little boy,
that says
let
this is the
Karen
speed he
know.
was hit at 24 miles an hour.
You have a hypothesis at what speed you believe there was impact. You have a point of impact.
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Let's talk about the other information you don't have.
Okay.
You don't have the information.
You don't know shit.
From your alleged point of contact to where Mr. O'Keefe landed, you don't have that.
No, he's pointing out if they had done actual testing where they damaged the Lexus, they only, like, his argument is, and this kind of goes into what I was arguing, Luke. Remember, his argument is a crash test dummy is going to fuck up the back half of the car. Because remember what we saw going back here. Hold on, 6 minutes or 6 hours. Where is that impact? Where's that impact he had? Where's that impact from? Where's that impact video? That picture. Is it here? Where's that impact that he does? Yeah, here we go. This will make my argument for me. All right, chat. All right, here's the thing. Notice, if they used a real person colliding with a car, look what it did. It crumpled up the fender. It bent the bumper. That bumper's getting replaced. It's probably cracked. The taillights jerked around. This hood's bent. So guess what would happen on the back part of a car? It would get smashed up. Well, guys, just let me finish. Let me finish what he's going to say. with that, his argument is we'd smash up the car. And his argument is if we didn't do it right, you would be shitting all over us for it, which is true, unless he would. But I thought his argument was John O'Keefe's arm blew out the glass. I mean, is he telling me the point is he's admitting they can't repeat the experiment. Yes. Right here, Digital Void. Yes. He can't repeat the test. He's admitting they can't redo it. But imagine it's the back of Karen Reed's car, and one of those crash test dummies made out of hard material hits it. And the back half of it, I mean, here you go, guys. Here's what, the point is, if he did that and the crash dummy hits it, you're going to need to replace the bumper. You're probably going to replace part of the panel here. You're probably going to have to replace the lift gate. You're going to have to replace the glass. Maybe you have to replace the spoiler. You'd have to replace all those different things. So he's saying that, oh, John O'Keefe, we would have destroyed all this. But that's not what you demonstrated. Remember, the argument is he hit right here in a glancing blow, and that's the only part he really hit, which is not something he could do ever again. So he doesn't have to worry about reselling the car. He wouldn't need a fleet of 1,000 of them. He would just need 1,000 lights to retest, because it just buy scuff, 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 and you could survive that. So that's why. Yeah, the whole thing. I mean, you'd probably blow out this window. You might blow out this window. You damage the whole quarter panel here. You damage the bumper. You damage the bumper here. You damage the lift gate. You damage this whole thing. So that's what I was getting at here. Then why did they buy the car? Because they were half-assing their testing. So, re-listen to that answer. No, guys, I'm listening to you. Yes, he's pointing out we couldn't keep replicating the test. And because we can't replicate it, you come in there and say we didn't fucking do it right. He's saying the exact same thing. He's pointing out we can't replicate it and all we do is damage cars. And I'm pointing out, well, wait, I thought it was only damaging the taillight. My argument is he's reinforcing the notion that John O'Keefe getting hit by this car would have fucked it all up. If John O'Keefe would have got hit by a glancing blow, there would have been damage all over this. Cracked panels. These panels aren't metal. They're plastic in spots. The bumper would have cracked. There probably would have been window damage, or this window's damaged. That's what I'm getting at. So, yes, that's not what he said. That's not what he said. We'll go back to this. We'll rewind it just to do it. That's not what he said. So let's go back right here. Okay, so okay. Here. So let's get to it. Shit, hold on, chat. Shit, I need to switch you guys over here. Sorry, here we go.
Or excuse me, that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mm-hmm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you?
Of course.
Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with the Lexus at 20 miles an hour.
You could have done other tests
Why not? It wasn't going to hurt you, is my point.
where the vehicle was going at 20 miles per
Unless you're admitting it would have fucking killed you, which defeats your theory.
hour if you used a crash test dummy, correct? You
If
could have
you-
done that.
If you use the
So here's my point, and listen to him.
right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information.
He's not saying that it would. Do you understand now, Mike and Luke? Yeah. That's the point. He's not saying he's not doing it because it would hurt the case. He's not saying I can't replicate it. And then he has to come in here and explain why he didn't do it right. That's what he was arguing. Now do you guys understand my point? If they had had a crash test dummy a car slam in the crash test dummy, it would have destroyed the car. Yes, I think it's the quiet part out loud. Yes, but I think that's more of a I can't repeat the test, therefore it's not scientific. So, yes, he is saying that this was designed to fit the outcomes. He had his outcomes he wanted to fit too. I feel like we're making the same point. Okay, well, fine. Fair enough. Fair enough. Let's keep
Information
going.
to be able to conduct that testing.
So your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis.
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
You know, you have a hypothesis at what speed you believe there was impact. You have the point of impact speed.
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road.
Also, if that one dude is in here about the whole Karen Reed speeding thing, he just admits you actually don't have a theory. So, womp, womp, womp.
We don't have enough information to determine that.
Let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
You don't know that. I'm going to go through the information that you don't have.
Okay, nope.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal
That's not
point of the
scientific at all,
testing.
though.
That's why I did the testing. That's why we're calling it paint transfer testing.
Right. But my question is,
That's not scientific at all.
you use paint tests as the focal point. But aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination,
We're trying to figure out if Karen Reed killed John O'Keefe. That's all we're trying to do, buddy. Yeah, this is a big deal. Turtle Boy is saying that I think the jury will take this guy seriously. I think so too. This is a very dangerous witness. This is a very dangerous witness. Unless he has to kill him. Unless he can't let him survive. So, but yes, we're talking about killing John O'Keefe with a car, sir.
you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger
Okay.
is in the middle of the event.
Okay.
Give it the chart, please. Your Honor, I'll give you the, as soon as Mr. Woke gives it the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Woke to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Are you on 33, sir?
No, I'm on 36.
Mr. Woke, you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the
It's
other.
on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Woke, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep, they're to the farther to the right.
Oh, I'm not the only one that has problems.
Okay.
You still
Sir, do
don't
you
have it.
remember testifying about this? To the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So if
can
you
we
take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward. And then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right? We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay, is that the 87 number you were
Hold on
referring
a second. You asked me to identify. So then it's see where the one next to it says minus 53.429.
Yes.
If you go up, so it's not a little bit down, a little bit, and see where it's changing directions at 34.157.
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50 something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you
Just hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
What? What?
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then
Okay.
it came back 80, another 53 feet past where it went.
Exactly.
Okay.
So
Okay.
you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, that was clear. It initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So
Wait, so this whole, it went 34 feet and then it went 53 feet backwards? Well, is that really true? Oh, well, actually, no, it might be different. What? Really? And this whole time he's talking about 87 feet total and he doesn't actually know how far they went? Yeah, the data doesn't lie, sir. Sir.
at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
Well, that's my thought too. Did she throw the car? Did she do it like a fucking? Did she throw it in reverse while the car's still going forward and just trying to grab in the gearbox? Is the transmission starting to like cut teeth or the teeth shearing off? Yeah, like okay, I think it would survive. You wouldn't blow out your transmission all the way, but you would definitely hurt it. I'm sure she'd shear off a couple of teeth doing that. Yeah, that's wow. Okay, well, guys, nothing can be 100% certain. That's actually the sign of a true person of knowledge, that there are no absolutes. I'm certain there. You can be absolutely certain there's no absolutes. And yes, that is an absolute statement, but now you're getting into Redditor territory. Don't do that.
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have
Yes,
at the
there would be
bottom
traction
in
control
that
warnings.
yellow-orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
The voice straight, no strays. Okay, I don't care what she did. I don't care if she took a shit on John's things and said she did it. If the evidence doesn't support her doing it, she's not guilty. I can admit to robbing a bank here next to my house. That doesn't mean I did it. You still have to prove I physically did it. You have to prove she physically hit him. So, yeah. Just saying.
And a 0 represents neutral?
I think it's either neutral or parked. I'm pretty sure it's neutral.
Well, if
A
it's
1
neutral or
represents
parked, that's a
drive?
big
Correct.
fucking deal.
A 2 represents reverse?
Correct.
Or a 2 can represent slowing down, is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down?
I didn't
hope not.
recall
It
that.
doesn't. So those numbers simply represent is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay, so if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolk. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Alessi, so is this 30 or 31?
Yeah, I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do.
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do.
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet, correct?
Correct. The one exception is column N, where it says shift position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Wolk, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage. Is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35.
Wow, I like this.
Sir,
which slide would you like to pick? That is just an asshole comment. These guys are just being assholes. This is brilliant. Brilliance, chat. I fucking love it. I love it. What's up with the judge? Bev is a spaz. So I don't know what to tell you. Don't know what to tell you, chat.
I've highlighted the slippage.
Exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
in reverse.
Okay, got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is
SAR?
You can have an accelerator pedal depressed greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this, Mr. Chairman.
Why? 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 What do you need a sidebar for, Beth? Beth! Bev, come on, Bev. Paul's like, engineer man losing to lawyer man. Paul not happy. Paul's like, Paul wish have Zin now. Could pack a fat dip right now of Zin. And he's just like, doop doo 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 dee doop doop boo doop boo doop boo doop boo boop boop boop. Come on. So she interrupts Leslie's moments. Yes, I do think this is shitty how she always, but the reason, like, Hank is intentionally bogging things down too. But yes, Paul just like boo doop boo doop boo doop boop boop boo doop ba doop boop boop ba da ba doop boop boop boo doop boo doop boop.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
And your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them people that were there for that entire window of time, or just?
Yes, 12 to 1.
Oh.
So Mr. Leslie, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in
No.
time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind
Oh, so
it.
he does know about Brian.
That is my
Wiggins.
understanding. In terms of on the street. is
On
your
the
question.
street, exactly. And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup.
Did you have any understanding as to whether there was
Wait, who the fuck's got the
Jeep vehicle
F-150?
on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
So I'm going to let that answer stand what he's just testified to. Just go ahead and.
Okay, so Dr.
Okay.
Welcher, what I want to do is to have you,
Oh, the Nagels. Okay.
using your data, you say 87 feet for the backup, correct?
Correct.
1162, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with the vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What information? do you
Brian
have
Higgins was there, but
with
he didn't
regard
leave
to
early.
How many vehicles are?
Yeah.
of 34
Brian
Fairview
Higgins was
at
there for a
this
long
time?
time.
So I have Ms. Reed's interview statements. I have statements.
Brian Higgins didn't leave till well after 1. Brian Higgins got to the police station at 1:30, and Brian Higgins said he went from the police station from 34 Fairview to the police station. Wow. Fucking Alessi's weaving some shit together here. Yeah, he didn't leave till 1:30 because he went straight to the police station. Woo, buddy. Oh, buddy, Alessi. There you go, homie.
Of a number of witnesses. I don't know if I'm allowed to say the names.
Are we just seeking? Well, no, the jury has no idea what to notice right now, so they don't know what the hell's being talked about. So no, this is not no, the jury doesn't have to notice it because there's nothing to notice. They don't know who these people are.
Say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60 something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I need my slides.
It was 50.
50,
Okay. Yeah, go ahead.
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an
Right.
hour.
So if anybody's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But again, that's been decades.
Right.
Why the hell were you driving? Okay, well, whatever.
So 87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, meaning like every possible location on the road it starts from?
Correct.
No, there's some spots. If you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right? The
Conditions
weather,
have nothing to do with where you.
This would be funny. Yes. Have you ever done it having a BAC of 0.20?
to finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting? You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah, highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you, under your method
Wow.
of analysis,
Well, I just want to make sure I heard that the whole way through here.
that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah, highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and
Okay, well, yeah, everything's possible, chat. Like, that's not the own you guys think it is. That's not the own you guys think it is. Like, he has to say, yes, it's not impossible. But is it probable? So I get it, and I guess now it makes sense. All the tweets and people making jokes. Guys, that's not a booyah moment. That's not a booyah moment. I'm just saying.
probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No. It could have.
Okay. Now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167. Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know. I characterize it that way. What happens is, there's 6,000-pound vehicles coming, and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir, I'd like to
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know it's not your fault, but
On the
sometimes it
image,
doesn't
the
show.
upper left. I mean,
Yes.
technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
The
I'm talking.
biceps goes all the way to the elbow, so do the triceps.
Right. So I'm talking about the two that are the farthest up.
Correct.
All right. Would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with a test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light, the laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle if this is me and this is the car, it's pushing and pushing across like this. And with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay,
And my slide shows this quite clearly.
So you disagree, you do not agree that the injuries to Mr. O'Keefe's forearm under your theory would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory,
Mhm.
right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay. Isn't it the case with your theory that the tail light would have to break? And after the break, the arm would have to maintain contact with the arm as the car moves.
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the tail light would break, and also the arm would need to maintain contact with the tail light area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe?
The biggest thing here is he can't explain how once you hit and you're like, and you're spinning away, how do all those shards keep hitting you? Like they're all moving forward still. Like it doesn't, like I said, this sounds like it's a fucking claymore.
The arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight.
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct.
And
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
so now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. Because you
No.
didn't do that in your report.
Nope. Always apply the laws of physics. The paint.
All right, chat. This is something here. This is a good spot to hold up for a second. Afix did some pretty good stuff here, and I wanted you guys to take a look at it. Let me see here. This is actually pretty helpful. I was reading through this, and it helped me a lot. So, this, I think, does a really good job of kind of breaking some stuff down here, you guys. I don't, he said, feel free to check his math if you guys want to. But this is, the colors equal the outcome reads as the lines equal impact force. But here, like, he's showing, like, what are things here where, like, at certain speeds, you're getting bone fractures. You know, the taillight shatter force is 500 newtons and the bone fracture force is 3,500 newtons. It's he's going there. Yeah. This point should have been made hours ago, too. I think so. And he says, I can send the code for everybody else who wants to play with the numbers. Okay. So. Well, let's go, Brandon. There's no bums out wandering around Massachusetts. So. Yeah. There's no bums out there. 3,500 is not for a forearm. Well, that's the only other thing I was confused about, too. But this is some stuff he put together here, guys. And we can look at this coming back, because if they're not done today, yeah, 900 newtons a forearm. Okay, well, yeah, there we go. Yes, label and charts. You can be the chairman of Aperture. Yeah. So, anyways, here we go. So, anyways, that's what we're looking at here. If you guys want to take a look at that later, but Afix has that up. But yeah, none of this makes a whole lot of sense here. So we'll go back to this. You got to show the first image to the left. It's a little simpler. Oh, okay. Well, yes, there are bums. They're not bums wandering around Canton, Massachusetts, chat. That's your problem. The bums aren't wandering around Canton, Massachusetts like that. So this is the other one he wanted to show instead, without everything else on it. So this is what he was trying to argue. His point is ultimately anything greater than, you know, a couple miles an hour would have been damaging. Yeah, basically, at 10 miles an hour, he would have destroyed half the bones in his body. And that's my point, too. That car would have been destroyed. The dash blue is lethal energy. Okay. Well, there you go. So, Kat, my name is Karen. Oh, though it's something Afix put together. Afix, if you want to put your link out there, you could post it, and we could people could take a look at it. So, well, yeah, it's way too late to do forensics on 34 Fairview. So, it's totally not happening there. Yeah, Red would be dead. Red's going to be dead. It's severe injuries. So yeah, there we go. Let's go back to this. Thank you, by the way, Afix. That was really good stuff.
Experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillight relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law as we already went through. But again, those simple position arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report that said these are the laws of physics. I would say these are the numbers. But for example, the timing in GPS, how a clock times.
He's getting mad unless he's getting under his
skin. Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
It's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
And I think that's fair to say, yes, here's how the forces would apply. Here's how they translate.
Where?
2A, 2A Roman numeral 1, 2A Roman numeral 2, 2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where?
Can you read the next sentence?
I'm sorry. Is it C PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis, but in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's go to the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry. Picture's down.
I'm sorry, we'll take that down. Thank you. Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are a blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only 2 variables you need to answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations, but again, it depends on what's being hit.
We're
example,
getting
if I
into
have something
nerd
that
territory
bends
again
as a
here,
result of
chat.
the
This is
impact,
not
it can
helping.
bend up and create
Yes.
a vertical laceration.
So you would agree, based upon what you said,
Yes.
that generally horizontal movement
Did John have no clip turned on? Is that what happened here?
of a car would be expected to cause horizontal lacerations.
Generally,
Okay.
yes.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the test.
Do you want, we bring up a slide? Will that
I'd
help
love to
you?
bring up a slide.
We're going to be running the thing, so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it, but I think we've got a slide for you. And what number? 111 is on the screen, sir. Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car's moving is probably a little better representation.
Sir, I'm just asking you a question about this slide. If
Okay,
you could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All right. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with a taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices this outstretching of the arm? You had to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion to hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes, you
asked.
have. You asked me about the totality of the rear of the Lexus, which
No,
includes the
you
tailpipe.
talked about a
All right.
tailpipe.
I am not going to be asking any questions that involve the taillight.
You
in any
talked
fashion.
about the
So what I'd like
tailpipe,
to do is
brother.
to go back to the question that I'm asking,
Mhm.
which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, I think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything right?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. It could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight on a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists identify various hypotheses, go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not. So I eliminated that as a hypothesis. I tested the steering. I tested the transmission, 1, 2.
See, if I was Hank, I would have asked all these things. I would have made him go through all the stuff he would list off. This would have been very effective on direct. This would really take the wind out of the sails of the defense. But that wasn't done for some reason.
Represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do one static and 2 dynamic tests in very similar positions.
Did you?
So I did a
I
total
don't
of
think
3
you did,
tests
man.
relative to the arm.
Where's the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
All right, so Mr. Alessi, I think if we're going to,
I am, and I'm going to move on, Your Honor.
So
okay, but Mr. Alessi, hold on, we're going to do that for you.
Can I ask, I just have one other area. Your
Wait,
Honor.
what are we
In short
voir diring?
order, if I could,
Okay.
please.
What are we for doing?
Go ahead, finish your answer.
So slides 109, 110, 111, actually through, I guess, 121 deal with the testing of the hypothesis.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did
The
you
answer is no.
engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
debate.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do and we don't need you waiting there while we do it. So tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here until, we won't go until 4 tomorrow.
Oh,
Those 3
tomorrow's a
questions
half
are
day
discussed
anyway.
in case
Okay.
anyone, don't do any independent
Okay.
investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. Fourth admonition, please be very careful with your social media use. We'll see you tomorrow morning.
Rise the jury.
All right. So, have I had the pleasure of examining a quack like this? One time, kind of, but never in a criminal case. I've had like
Okay, Mr. Rossi,
retarded.
it's your voir dire.
I've had like a really retarded lay witness, but no expert ever like this. I don't know what this voir dire is about, guys. So, and then real quick, we got to catch up on some more of these. Let's see here. Natasha, very good, says you're actually vulgar. Well, I don't know if that's a compliment or not, but thank you. Okay. T-Rex Truckee says, I know when I was watching this earlier that Sean will lose his shit. This is absolutely insane. Let's Go Brandon's been a member for 16 months. Says, I like the way you think. You're a sexy beast. Well, thank you for the support. And 16 months, yeah. And 2.0 thinks I'm a sexy beast too. So that's all that matters. Keopathic says computer science is praying to the machine spirit, and this is more scientific than what he's doing. Yes, I tend to agree. And then Brandon says, okay, fuck, marry, kill, Billy Joel, Bruce Willis, and a foot-long meatball sub. Okay, so I'll kill the sub by eating it. I'll eliminate it. I'll marry Billy Joel because he can play the piano, and then I'll fuck Bruce Willis because he won't remember it, so we can't tell anybody. So it'll be our little secret. Shh. No Mail says the Reed Sims are on life support. I don't think I'm on life support. I'm just like, this was not what it needed to be. This is kind of a draw right now. This is a draw. Leslie fumbled really hard at the beginning. So it's not a loss yet, but oh, buddy, this is not where Karen needs to be right now. Alessi should have been whooping ass all day long. So. So, anyways, we'll keep going here.
We're on a very limited schedule here. Okay.
Okay, Your Honor.
Oh, Billy
Mr.
Joel's
Wilker,
having
with Your Honor's
hydrocephalus?
permission,
Oh,
if we could
no.
Pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36.
That's not good.
You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced
Sir,
it.
I got to
don't
look at
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh, correct,
And you had that in your original report, but you removed it in subsequent reports, correct?
correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Ooh, I think I know where we're going with this. He heavily relied on Trooper Paul.
If we could, Mr. Woke, go to diagram 1. Do we have that electronically? Of
Oh,
Trooper Paul's
buddy.
report.
Did they really?
Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took
No.
that image and you put it in your January 30th, 2025 PowerPoint, correct?
Pulling up my version of PowerPoint. Yes, it's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With Your Honor, why do we?
Well,
I have limited. Go ahead.
so that particular diagram I did not use. If you notice, the diagram I used has different cars and doesn't have all the writing about the position things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report.
It's not what Alessi asked you.
We have a hard copy of Trooper Paul's.
Could you turn the lights on, please?
Alessi's doing that for the record to show this guy is obstructing and slowing things down.
Yeah, approach, Your Honor.
Yes.
I'm going
Show
to.
Mr. Brennan.
Yes, Mr. Brennan, this is. May I put you on this? Excuse me, Dr. Welcher. You see this first page, do you recognize this as the cover page for the Trooper Paul report that I was referring to?
Something show the signature.
You want to look at the report, sir? I'm not so sure there is a signature on the report.
Signature block right here.
Yes.
Trooper Paul, page 16.
I have that.
Yes.
Okay. Now, what I want to do is to go to diagram 1, and if I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass top, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different.
Okay.
None of this stuff is here.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Let me go, Mr. Wolf, to the January 30th presentation.
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
I think it was from the file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close
Uh-oh.
is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Right. Yes. You're welcome. Do you know of any other place you could?
Now, is
have-
that
let's
so
put the,
damn hard?
presentation back up.
Was that
On the-
so damn hard to answer the question that way? Holy Jesus. What a horrible person. Can't answer the question.
The slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not my
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay. Did Trooper Paul
That's not the only you think
work
it is,
on
buddy.
any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Yeah, he thought he was William Dafoe in Boondock. Yes, I'm huffing.
Sir, let me know you've had a
I'm
fair
huffing the
opportunity to answer that
finest.
Yeah, give me a second.
I'm huffing the finest of acrylic paints. Yes, the finest of
Yes,
the acrylic
came in a
paints.
file called cars-trp.jpal.
Okay, so it came, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes.
that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Can you read the file name again that you just read?
The folder name
Yes.
is
Oh, he's getting big mad.
cars-trp.jpal.
Okay, and did you get the drone image from that file folder?
I did.
Okay, thank you.
You're welcome.
Now let's go on to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25,
I'm
26,
Galaxy
and 27.
Tester. Yes, so he's just admitting he got stuff from Trooper Paul.
Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I believe.
Okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar, okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Let me ask you this so I don't keep going back and forth. Do you have access, sir, to the cars report of Trooper Paul on your computer?
Think so? You remember the name of it?
I don't. We'll do it there with a hard copy. Mr. Bernard, I'd like to show you. Thank you. So if I could approach, Your Honor?
Yep.
So you see what I'm pointing to right here, which is page 10 of Trooper Paul's cars report. Do you see that?
Is this the same report dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare, this is the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's broken.
Okay.
So that's okay.
Okay, so we have that report, and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay, all right. Now let's go to
God, he doesn't want to answer the damn question. Just answer the questions, man.
your, continuing on the same slide. If Mr. Woke, we could go to slides 22 and 23.
You are fighting way too
This will be
hard.
the last on this, Mr. Lessie. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor.
God, he is fighting so damn hard.
You see these photos?
I'm sorry.
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Yes.
What do you recognize in terms of the person in it?
Oh.
What about the number?
It's just these three photos?
Any photo that would be this photo or any photo similar to it. But let's start with just these three.
If I have to limit it to these three, I don't know who that is.
Okay, and if you don't limit it to those three, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
I have photos of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any
Ooh,
understanding that
oh.
there's any other trooper that would be doing this type?
Oh, are they claiming Proctor got in the fucking car? Uh-oh. 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 I think that's what we're getting to here. Also, oh, I know. Are we trying to claim that Paul's key cycle is known? Yes. Unless they're also trying to claim Proctor fucked with the car, too. I don't know. Unless, you know, Paul fucked with the car a couple of times too many. Yes, the reason why they're closing right at 4 is the courthouse staff. She can't keep them longer. They have to pay them overtime. That's probably the thing here. It's a big deal. So it's the key cycle. So they're saying Paul fucked up the key cycles. Okay. Okay, here we go.
Type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle doing what's depicted here.
Someone's inside the vehicle taking the photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you. Your Honor, that is,
Okay, so next topic.
yes,
Go right
thank you.
ahead.
And I just need to reload, if you will, with regard to that topic.
Dildos. Come on.
If you could, if Your Honor, you can go to slide, and I think I can do this fairly quickly.
Okay.
If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation, and it's now 132. I don't believe that's the right one. It's the
One before that.
I think yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Woke, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorty Bellows' autopsy.
Real quick chat, Joe Loy, are you still here, Joe? Joe, are you still here? I don't know if I could see her. Oh, she's commenting. Yep, Joe Loy is here. Joe, I just got your. I feel like I'm steel toe when I do this, but to my PayPal for $12.91. Joe Loy for $12 said Clyde coin to the moon. Well, thank you, Joe. I'm assuming that's for 10 pounds. So thank you, Joe. I very much appreciate it. Thank you, Joe. So, all right, let's keep going, chat.
Autopsy report, page 3, correct? Is that where you got that from?
It's from the report. Take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out and go to the multicolored image in the center, up at the top. Yep. Thank you. If you can go to the very top line.
You can hear Bev sighing. She's just fucking, she's like, I got margaritas waiting, boys. Let's go.
It says autopsy report performed by Irene Scorty Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay, you are all set, Doctor?
Thank you, Ron.
All right.
Okay,
Did you
well,
have any
he's going to
questions,
get
Jerry?
fucked tomorrow.
Okay.
Oh. Remember, guys, this is for our dear outside the jury. Also, real quick. So one of you asked a question about who is the guy next to hold on here. Eliza's saying, does anyone know who the guy sitting next to the podium is? Is he there every day? Oh, hold on here. Let's get to that. We'll get to this then. I guess we'll see this. That guy sitting in the back right there? I don't know. But you can see they got a rope there, so that's like right on the edge of the seats.
Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
Did not use his report at
It
all.
was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair?
This guy's apparently the Commonwealth's appellate attorney. Why is he sitting back in the Karen Reed side of things? He should be sitting with the Commonwealth or somewhere else. Forcing him to sit there, that's unfair to Karen's team.
To say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider
Ooh,
her
let's go.
conclusions
That'll be
regarding manner of
interesting.
cause of death as a
Hmm.
basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion? Did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scotabello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scotabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just gonna
I have
decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scotabello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here for the autopsy report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke. But you recall the slide that you had has the final diagnoses of Dr. Scotabello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You
Correct.
considered them.
Correct.
Thank you. No
You're welcome.
questions, Your Honor. I
All right.
appreciate that opportunity.
So I'm not gonna let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Leslie, how much longer are you going to be tomorrow? Oops.
What?
About halfway through, Your Honor. I think it will take up, look for it tomorrow. If we can get the things quicker, I would like to do that, but given today, that's my best estimate.
So
That's the reconstruction.
we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow and we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So
Ooh,
I'd
okay.
like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is a key aspect of the case, and we've got to be able to proceed through to the question. He covered a
And-
lot on his direct and deed property.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
That would be my answer. If that's the case.
Okay. All right. Thank you.
All rise for the court, please.
Thank you, Dr. Welcher.
Thank you, Your Honor. Can I step down?
So, all right. Well, there we go, chat. I think that's it. Yep. All done. 7.5 hours and 5 hours. There we go. So, All right. Well, ultimately, chat, yeah, unless he got some stuff going finally, he spent the whole day fucking around. I'm not impressed. I'm not impressed. This was not a good day for Karen. They survived. They didn't die today, which is fine. You didn't die. You didn't die today. But are you live? I mean, you're still in the fight, but whoa. This is not good. This is not good. Guys, we'll get to Hank's motion here in a second. What was the thing they did without the jury? They voir dired where he got some of his information. I think they're gonna knock some shit out of Welcher tomorrow, or try to. So they poked a lot of holes, Mike. They did, but Alessi pissed those away for so long that I don't know if those landed. I don't know how well they went, because a lot of times he tried to poke holes and he got nothing. So right now, this is a draw. This is a tie, and that's not good for Karen. Karen has to kill this man. They have to kill Welcher. And if they kill Welcher, Arca has a fighting chance. If they don't kill Welcher, Arca's pretty much not going to matter. If the jurors see this guy with enough credibility, Karen's fucked. So this is it. This is game 7. This is the witness that fucking matters. So Karen has killed enough men. Yeah. Everett Scott says, I've seen a judge get away with not allowing any defense at all. I'm talking no calling witness case in chief. Right to closing despite the objections. I can't imagine that happened. You must have seen something weird. That just seems weird to me. Yes, that was a voir dire. They questioned him about things outside the presence of the jury, because I'm sure Alessi wanted to bring up whether or not Trooper Paul can be brought up right away. How much more of Trooper Paul's shit can be brought up right away? Because remember, she gave him a very narrow path to run, but if he can expand it to running a Mack truck through it, that's easier than threading a needle. Cacophony says, no, it's not. The expert came across as well as Destiny or Pisco does. I don't think so, man. I don't think so. I think, remember what I said at the beginning. I don't know. I was not impressed today. But I'll bring this up again because this deserves to be seen. This was not a home, like, nobody hit a home run today. You know, Welcher looked like a turd, but Alessi did not score where he needed to score, guys. I mean, here's the 2 different trials people are watching. 2 very different depictions of the jury. Sue O'Connell saying, oh my gosh, they're paying attention to, it looks like Alessi's whooping ass. You ask the other guy there. The jury looks bored. I know you don't have to like John DiPetro, but maybe he's right. I don't know. Could easily be. It could easily be, and that's the scary part. We don't know right now. We don't know. So, Toto Vader says in Minecraft, no, in real life. Yeah, Welcher punched himself in the face, but it doesn't mean unless he kicked his ass. Yeah. Stoom says that the jury is dumb as me. Well, me? I mean, like I said, if you think this was a home run today, brother, you got another thing coming. So, SB Seller says, nah, if Bev doesn't pull some bullshit tomorrow, Leslie's going to lock him into things that couldn't have happened, is gold. Hopefully, but we don't know what's going to happen tomorrow. We'll find out. Trump 1 says, how can the state ever trust this guy again after this performance? Remember, he's a paid whore. And his job is to suck whatever dick you present. Because he's a whore. There will always be a need for whores to suck someone's dick. That it's a recession-proof industry. So there'll be some prosecutor or some insurance company or some private personal injury firm looking for their services to say what they need to say. Like John Mayer says, say what you need to say. They'll find somebody to do that. So they'll never this is not the end of them. They'll keep moving along. It's not the end of them at all. Digital Void says, up for $5. Thank you, by the way. Thank you, everybody, for your super chats and all your comments. I appreciate how honest you are. Well, thank you. I try to be. You say things we don't like when you can easily just gaslight and appease. Even when you're wrong, you're honest. Well, who says I'm wrong? I hope, here's the deal. I hope I'm wrong. This goes the way it needs to go. And when it says we've in jury find the guilty, Karen Reed, not guilty on all counts, you can just go, my chat just is, it's a million people here just screaming, suffer, fat man. And there's a million comments in here and I have to read them all of you guys saying, suffer, fat man. I'm fine with that. I'm not sure that's going to happen. But I appreciate it anyway. Thank you. Thanks for the super chat. And Digital Void is a new member. Thank you. I appreciate that. Joining the cause to help make America green again. Getting those H1 green visas. We're getting rid of the grays, chat. Grays, keep moving. This is a green neighborhood now. Oh, so. Yes, I do know in the Whitmer case, the judge only allowed the defendants 50 minutes each. Yeah, well, that, like I said, there's times where some bullshit does happen, but this idea of no defense at all, straight to closing, I don't know, something happened there. I knew they voir dired him today. Okay. So he came off poorly. I hope so. No, ARCA will put this guy's testimony in this place. It wasn't a loss. Hopefully, but we'll see. Hopefully. I'm thinking like a lawyer, not a juror. Well, that's all I got to do. I don't have experience as a juror. And in my experience, jurors are a lot of jurors are retards. So, what am I going to do if they're acting like tards? So, John is a loser cuck, though. Yes. What's up, John O'Keefe? He's a cuck! And he's dead! DePetro said Jed McCabe didn't look good, didn't he? I don't know. I don't really pay attention to him too much. I just like Turtle Boy fucking with him. So. Mike says if Bev's rushing court not to use overtime is that appealable. Well, no, it's just she cuts them short and then okay, stop here. We'll start tomorrow. She's not limiting things. She's just limiting the amount of time each day. So if they have 10 hours of cross, you'll get your 10 hours. It might just be, 5 hours, 3 hours. And then, it'll be broken up, but you'll get all the time you want. Did I look into the documents where Welcher got discredited? He didn't get discredited. I know people are trying to say he got discredited. He didn't. The court said that the expert that he bases shit on is not allowed. Therefore, he's not allowed. Ultimately, that was the thing for Welcher. He's not been officially discredited by a court. Stupid saying, I didn't say it was a home run. That's a Nikita level response. I'm not, but I know people are saying on one side or another, the Commonwealth kicked ass. No, the defense kicked ass. Nobody really came out of today looking good. And that's a problem for Karen because she can't afford to have days of draws. You got to be winning. She has to close the distance. So let's see here. Yeah, I think some of the day may have been set up. Yeah, but hopefully, but we don't know. And even then, they've got to keep the damage on this guy. If this guy survives, it's bad. It's bad. I am so wrong. I hope I'm wrong. I don't know if I am, though. Some old trap says, geez, sorry, I don't have disposable income right now, Sean. What? I said thank you to everybody who's here. Jeez. Do I think unless he's gonna ask him about Chloe? No, because he won't have any idea that no, because you look like a dumbass asking him about Chloe. I will spend so much money on Suffa Fat Man super chats if she's acquitted. Well, there we go. I hope that happens. I hope that happens. Justin Smith for 19 months. Thanks for the support, Justin. I appreciate the longevity here. Suffa Fat Man. Thank you. And yes, he did not control the witness today very well. But this witness wanted to fight. I mean, there's only so much you can do. But yeah, he didn't do the best, I think. So, is it possible they're just tired and want to present their case? No, you can't let up. They have to keep the pressure on until it's their turn. That's like if you're on defense in football and you're like, it's 4th down, we'll get the ball back in a second. No, you're playing fucking, you're not playing zone, dude. You're playing fucking hard nose. You're like right here on the guy. You're like right here. You're playing hard nosed in the secondary. Like you're not giving any room at all. There's no cushion. You know, we're not playing, no. You're right up on your guy. You're playing man. So Funky Monkey says, you never served on a jury? No. The only time I got jury duty notice, I was in college and I had already moved, I was in college. And the town where I nearby, is where the court is. They sent a jury duty notice, and my mom was like, hey, they sent this. Do you need to and I called, she called me. It's like, hey, they called you for jury duty. And I'm like, well, I'm in fucking college. And she said, can you print out something you're there? And I did, and I mailed it to her. And actually, I think I brought it home that weekend. I drove home and saw my parents. I was like, yeah, here you go. And my mom mailed it in for me and never heard from the court again. So yeah, never anything else. Those Whitmer boys might be getting pardons. I fucking hope to God they do. I hope to God they do. But then you got ones who got fucked in Michigan State Court, so that's a problem. So let me see here. Are lawyers not allowed to be on juries? In some states, that is correct. But in Ohio, no. They're all the time. You can. No, I mean, I've called it. I've seen the jury duty, and the jury walks in, and there's an attorney and no, and you're like, what the fuck are you doing? And the judge looks at him. It's like, get out. I've seen that happen before. Jury walks in and Kurt's on the jury, and the judge looks over. It's like, hi, Kurt. And the judge is like, hey, judge. And Kurt's all dressed up in a suit and tie because he's ready to go to he's got court appearances later that day. The judge says, are you here as the jury duty? He's like, yep. The judge's like, get out. You're excused automatically. And he just gets up and walks out and goes to court. Does the things. That happens a lot. I've been in cases where you're trying a case and it involves something from the nearby little town. And one of the cops from the nearby little town shows up. And he's like, yeah, I'm here. And I'm like, okay, well, the judge looks at him like, get the fuck out. So it does happen, but some states you are banned from being on a jury if you have a law license. SB Seller says, today is also menstrual hygiene day. Tips? No, I don't know. Luke says, it's funny how hard you flipped on Turtle Boy. I mean, I didn't really flip on him. I still think what he did was pretty retarded, and the way he did it was really fucking retarded. Do I think the way he's done stuff since then is fine? Sure. But, I still think waving the fucking phone around on screen where you could see their phone numbers and stuff, that was a dumb fuck moment. I still think that was a retarded thing for him to do. And I'm sure that's what really enhanced him getting these charges. So, I mean, he set himself up. He made it easy for these corrupt shitbags to have decently, filed charges against him. So, no, I still think from the beginning, he was allowed to do what he does. The whole flipping on, or you mean the whole flipping on him where it's because of my whole Chili DeCastro thing, I figured it was all a bunch of garbage. I'm not sure which part you're getting at that I flipped, but I'm willing to bet a little there. So let's see here. Let's see what else we got. We're gonna wrap this up here, Checks. It's getting late. Just want to make sure I didn't miss it. To be fair, Bev did Dauber out in the totality she hit him opinion this morning. Yeah. Then real quick, we'll go over there. I'm Barnes levels wrong on this one. We'll see. We'll see, chat. Yes, Karen's first jury had a lawyer on the as an alternate. She ended up joining the defense. Yeah. Like I said, some states you're banned, but there's, Massachusetts, they allow it. Do you have to disclose to the court if you know someone on the jury if they're just a civilian? You're supposed to. You're supposed to, because that's part of my voir dire is like, okay, you guys are neighbors. You go to church together. If you guys happen to vote one way or another, are you guys going to hold it against each other? Like, are you going to be like, oh my God, I really want to I don't want to upset Karen when we go back to church on Sunday if I, voted one way and she voted the other way. And you have to ask those questions. Those are important. Let's see here. How did you did go from junk fuck juice to kind of getting his point though? I still got his point. I think he was fucking stupid about it. I'm not saying that his message wasn't good. I'm saying the way he executed it was pretty fucking dumb. And now, the stuff he's done since then, telling he hopes Tully and his family die in a fire and all that shit. His Tully's little retarded children. I don't think there's anything that's not illegal. I just still think the initial shit he did was kind of retarded. Not illegal, but still retarded and set himself up to fail. So let's place a friendly sandwich bet on this, Sean. Fine, we'll do it. What's the sandwich bet? Maddie B for $2 is for the goal. Also, guys, if you are new here, real quick, chat. I don't think many of you probably are at this point, but tomorrow night, 9:30, after we will start this bright and early at 6 p.m. Well, actually, no, hold on. We'll be at 5 p.m. We will be starting bright and early at 5 p.m. Tomorrow night at 9:30, we have the Thursday night show. We do that every week. Got a lot to talk about. The NFA bill is, buddy, I don't know what's going to happen there. The Chrisleys got pardoned. Andrew Tate's been officially charged in the UK with crimes. And there is an interesting case out of the U.S. International Trade Court, which you're like, is that a thing? Yes, it is. We'll talk about that and a couple other stuff tomorrow night at 9:30. So hope to see you guys there. Hope to see you there. Let's see. I'm not driving to Cleveland. You pick a verdict. I'll pick one. The loser has to buy a sandwich. Okay, fine. I'll take it. You pick a verdict. I mean, as of right now, because I can't say it right now. I have to see what ARCA does. But yeah, we'll see. Katie says this better give me 50 points. We'll see. Island saying, is there court Friday? I think maybe. I think so. I think. Ghost goes CLYDE. Clyde, yes. And I'll grab him real quick, see if I can get him to come in here. Hey, Clyde! 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 Click, clack, click, clack. I hear him the click, clacks. Hi, Bubby. Come here. Come here, Bubberkins. Come on. Hey. Hey. Oi. Hey. Clyde, come here. Clyde. Come here, Clyde. He's so close, chat. Clyde, come here. Come here, Bubba. Hi. Oh, yes. Ah, yes. We got the Clydes. We got the Clydes. We got him. We got her. Hi, puppy. Mwah. He's so sleepy. He's very eepy. He's a tired pupper. Come on, give him your a woo. Give him a woo. So, you guys summoned him. He's here. You summoned Clyde. All right, real quick, we're going to address this. This is something that Skink Brennan brought up as he cried and cried and cried. He cried. So this is a motion to preclude the attempted use of information not included in not produce a violation of Rule 14. So Hank is saying both the Commonwealth defense are bound by their discovery obligations. Yep. During the course of the trial, during his testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort providing the documents as a witness is being confronted with documents is improper. It's a trial by ambush and a violation of Rule 14. Bullshit, that's impeachment. And it creates needless delay, resulting in objections and unnecessary sidebars. The Commonwealth seeks a ruling precluding the use of materials that were not noticed by the defense, other than materials in the witness's CV during presentation or discussed during testimony. Well, it's a little late for that now, but that's a impeachment issue. It goes towards credibility. Why don't you object contemporaneously? I'm sure he did. Remember, there were a bunch of sidebars. But yeah, this is that's entirely logical. Your guy's CV was bullshit. We're allowed to test it. We're allowed to challenge it. This is I don't understand what Hank is Hank's crying. He's a quiet little baby. He's a scared little bunny wabbit. So, are the sidebars on the record? Yes, they are. So, look at how Hank spells his expert. What do you mean? I don't see the problem. Yeah, dated yesterday. Well, technically, Wednesday. It's still today. So, is it common for everyone to auto pen their documents? Well, when you do electronic filing, yes, you have electronic signatures, so that's not uncommon. Hi, Clyde. Can I set you down, Bubba? Huh, Bubba Bear? It's okay, puppy. Bub. Bubber dog. Clyde. Hi, buddy. Huh? All right, I'm going to set you down, Clyde. Here you go. Shh. Good boy. Such a good boy. All right. So, he did Shannon, not Shannon. Yes. Katie says, who's Caleb Schlesinger? Yeah, well. Mike says they referenced someone who didn't testify. Oh, well. It's all about, oh, well. Mike says there was never a Shannon Burgess there who testified. You aren't going to be able to play that game. You're kind of stuck with what it is. So it's not going to work. I love the toe the line of malicious prosecution. And they have Jim McCabe's Google search records right from Google, and they won't let him in. Yeah, well, like I said, guys, Bev is a hack. So shouldn't be too surprised. Bev is a hack. All right, guys, that is it for us tonight. We are all done. We're going to land the plane. The plane needs to land. We are, put your tray tables up. Yeah, guys, I heard the casino went for after last. I woke up at 6, I woke up at 6:15 and Worski had just been they had just switched over to Worski playing games and stuff. That was hilarious. So Yeah. Well, it looks like P2 for this race. You'll be all right. So, with that said, chat, remember 5 p.m. tomorrow, we will get started and we'll see how. Guys, this is a do or die for Karen. This is it. This is do or die. Dragon says, is it helpful for the defense to have so much legal coverage scrutinizing a trial with an army of helpers pointing out holes? I mean, these attorneys who have done these big cases have said, yes, they do take information we present and run with it at times. They do have an army of people. They do have people they're in contact with. Like, they admit they need to do this. You have to do it. It's helpful. But it's like, they're not watching me. You know, maybe like they're definitely in touch with Turtle Boy. Maybe they watch the Young Jerks. Maybe they're watching Emily Baker or Mark Bedrow. They're probably talking to him all the time. But like, yeah, I mean, they're watching where they can watch stuff. So, yeah, Keno's last stream was 10 hours long. Yeah. So we'll see. We'll see. Aaron says they're watching Tragos. Well, there you go. Peter does quality content. I'd like to think they'd watch me, but you know, they're probably not, and I get that. So, can Arca bring up previous clients and their opinion on an if an impact happened now or only one way? They could, but like they need, like it depends on what they could show, what they can't show. Who knows? Who knows? They're probably in the chats more likely than you specifically. Chats are more represented jury pools. They are, but I think they're also just taking advantage of what's out there. So, but you know, guys, besides Peter Tragos does great stuff. I like Peter. I like his stuff. I love the fact that him and his dad can chop it up like that. I think those are always pretty funny. I love those when he can talk to his dad. So it's pretty cool. It's pretty cool. Yes, Maddie, spam the shit out of this chat. Elizabeth Ann says we'll see you tomorrow. I have 1 degree of separation to Kieran Reed through this chat. Yes. So he doesn't have Clyde though. Yes, but he's got that swarthy hair. All right, guys. So we'll be, remember, guys, tomorrow night, 5 p.m. We'll be at this 9:30 show tomorrow night. We should probably be able to do locals like normal. And chat, remember, until next time, just because you did it does not mean you're guilty. And Karen Reed is still not guilty. She's not guilty as long as the day is long. They haven't been convinced yet, and I still don't think she did it. So there you go. Good night, chat. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was, he even knows he's fat. For all this fun and more, there's one place to go, here on Sean Martin's Potentially Criminal Show.
What do you mean I signed off quick? I'm still here. It's just we got to get going. It's getting late. I got to land the plane. It's got an abrupt landing.